to that FIR was listed before Honorable Court number 8. That matter was directed to be listed before appropriate bench because one matter was disposed by His Lordship. Yesterday, direction was given for listing yesterday. Yesterday, Your Lordship was not available. The matter again was listed before Court number 8 yesterday. The matter was taken up by Court number 16, and the court directed to listing for the matter before Lordship again. Petitioner is in custody, accused and lodged on bail, Lordship.
No, what to do now? What is your prayer now?
My prayer, Lordship, may I pray that matter be taken today, Lordship, at 2 p.m.
How can it be?
Lordship,
How
petitioner
can it be?
is in custody, Lordship.
Yes, he is custody. I can understand. That apart, I have a TV also.
CD is also here, Lordship.
I don't know if matter comes.
Then Lordship, tomorrow, Lordship. I'm praying for tomorrow, Lordship. Tomorrow.
No, I'm not taking the matter. You pray before the registry and proceed registry. Matter may be come up before tomorrow, before this court tomorrow. But how I can list it before me? Case record is not before me. So put up it before tomorrow. I'm not taking any mention.
I'm
matter
giving
also.
mention.
I'm not taking. Mention is getting court number 8. You make a mention before court number 8 so that matter may be listed.
May I please, Your Lordship? Lordship, today's list, item 14, Your Lordship.
Item
14. 1-4 for admission. I have some difficulty today, Lordship. May kindly for 2 weeks, Your Lordship.
You want any fixed date or list after 2 weeks will do?
Lordship, any fixed date may be given?
March, 25th of March.
25th. Lordship, there is an interim order that may kindly be.
25-3 interim be continued till next.
May I please, Your Lordship? Lordship, I beg to mention item number 24. In this case, Lordship, diary was called for, Lordship. Perhaps, Lordship, the diary is not there. And Lordship, interim is there also.
Yes, you are on interim?
Yes, Lordship.
As per my instruction.
City notice. City notice, it should remain. When it can be listed? (26th of March, 26th interim may continue till listed.
Lordship, I beg to mention item number 32, Lordship. Bail hearing matter, Lordship. Lordship, in this matter, my senior has difficulty to the Lordship. This matter may be kindly fixed on 23rd.
We have received this calco. It is a charge sheeted case, I think.
Yes, Lordship. Lordship, I am on interim.
You are on interim.
Yes. Can it be fixed on 23rd?
And then request made by land council for the matter is item. Let the matter be listed on you listed on 23rd of March. 23rd March? You want 23? 23. Interim be continued till next.
May it please, Your Ladyship. Ladyship, I beg to mention item number 9, 10, and 11 in admission column, Lordship. Lordship, with the consent of the other side, Lordship, I pray for an adjournment today, Lordship. Lordship, the senior counsel is having some difficulties, Lordship. It may be fixed
9,
after
10,
2 weeks.
11. These are all connected matters.
Yes, Lordship. 9, 10, and 11 is.
You are praying for whom? For the
I'm praying for
petitioner
the
or for the
petitioner.
respondent?
For the petitioner, Lordship.
I am for the respondent, my lord.
You are for the respondent.
Interim may be continued, Lordship. There is an interim.
Consent of the respondent to the land council for the petition.
I have a
It's
small,
matter of 2020.
my lord, I have a small prayer, my lord. Since they are enjoying an interim order, my lord, I pray for a short date, my lord. Fixed date, my lord.
We'll see to it.
Lord, if possible, 24th of March, my lord.
And it,
Or 25th. 25th March, if possible. 26th.
26th.
Much of it.
Please, Your Lordship. Your Lordship, with the consent from the other side, I beg to mention item 42 of the daily list.
Item 42.
42 and 43.
Lordship.
Forty-three, 42 connected with 43.
Yes, your lordship.
I am for the petitioner, Lordship.
You are for the petitioner. You're appearing for the respondent
Yes.
in all the matters. You are appearing for whom?
I'm appearing on behalf of RM Das.
RM Das.
Yes, your lordship.
RM Das is. No, you are saying you are for the petitioner,
Yes, Lordship. I am.
but
on
in
the-
43, RM Das is for
No,
petitioner.
no, Lordship. There are two cases.
Huh.
Lordship, I am appearing for on behalf of YS Mandan.
YS Mannan is petitioner for item number 42.
42.
Item number 42, Mannan is for petitioner,
And
and
43.
RM Das is petitioner for Swales. With the concept of the others. Your good name?
PCA.
Huh?
PCA.
Naam to nahi hai. Appearing on behalf of
Lord-
Mr. RM Das,
1 week.
Lordship,
the learned counsel for the respondent in criminal petition number 167 of the 2024, and for the petitioner in criminal revision petition number 345 of the 2023, paid for an adjournment, to which the learned counsel for the other side, MS. You are MS?
R. Begum.
R.
on behalf
Begum,
of
appearing
YS
on behalf of Mr. YS Yasmin, raised no objection. List 40 matters. We cannot fix here a date. We can
Lordship,
fix it.
kindly
One
fix a date, Lordship. Can it fix, Lordship, 17 of this month?
No, no. 30. 30.
Yes.
Both the matters will be on 30. Are in interim is there? In any matters? No.
Much obliged.
33 হয়ে গেল। এই দুইটা আইটেম একেলগে দেখি কত কেন মই appeal লিখিছো।
May I please lordship, item 30, my lord. But CD was
30.
called for, my lord. I think CD is not there.
Case diary receipt. Are you on interim?
Yes, ma'am.
CD not received, issue reminder. Yes, Portaku. Lani,
Interim may be continued.
interim be continued till next date.
Obliged, obliged.
Maybe, Lordship. Lordship, I recommend item number 31, Lordship. Lordship,
What is the position
maybe
of
CD
31?
is not there. Yes,
Interim was there? No.
yes, I am on interim.
You were on interim.
Yes, Lordship.
CD not received, issue reminder. 2/4 same date. 2nd of April.
Obliged.
2nd of April, interim be continued till next date.
May I please, Lordship. Lordship, I beg to mention item number 20, Lordship 20. Lordship, in the last occasion, TCR was called for, but there is an office note that TCR is not received, Lordship.
It has to come from which place?
Lordship, I have to
Three.
check that.
Portray বলেছে। জবারও আহমেদ 20
From Kamrup Metro itself, Lordship.
Pavo Metro.
Yes, Lordship.
What's the on the last date only it was called for.
Yes, Lordship.
Scan copy of office not registered, the scan copy of the TCR is not yet received. Issue reminder, raised table to the needful. Raised the matter accordingly. 19th of March.
Lordship. Item number 22, Lordship. I pray for adjournment of this matter. The conducting counsel is out of station, Lordship. Interim is there in this case, Lordship. 22.
Case diary received. Can it be detained for some days or? The request made by the Learned Counsel for the petition, matter is item CD receipt, CD be retained till next date of listing when it can be 17th of March.
Lordship, one more prayer, that is
Okay,
item number
it may be
21.
Can be continued till next date of listing. Item number
21, Lordship. Lordship, can it come together with item number 3, Lordship? CD is available in this item.
Today's
3 is a
list-
motion matter, Lordship. Can it
Okay.
come together with 3?
Okay.
Much obliged, Lordship.
I beg to
21
mention,
we have received CD. In 21 we have received the case diary.
Oh, item number 21 receipt.
Okay, no, no, she's
Item
paying
number
for list the matter with along with 3.
may I please item number 34, kindly adjourn the matter for that. 34.
Here we have received the scanned copy of the DCR.
Succeeded
Yes, yes. At the request made by learning council for the petition.
Monday next.
Are you on interim?
No, interim.
The request
Monday.
made by learning council for the petition. Matter is adjourned. Scanned copy of the DCR has already been received. List the matter Monday.
16.
No, not possible. 20.
Let's say another pair 27. Interim is
27.
there.
Yes, 27. Have you received the case diary here? You are on interim?
Interim.
CD not received is remanded. Let the matter be listed. With the longer date you can give. Item number 27 he is saying.
27.
Twenty-sixth of March. 26th of March will do. We are listing it on 26th of March. You are on interim?
I'm on interim.
Interim be continued till next day.
Must.
May
Yes.
it please your ladyship, I'm here for item number 26.
20?
26.
Ah.
In this case, the CD is not available. And we are, I am on interim.
Whether CD is there? You are on interim?
Yes, ma'am.
CD not received is a reminder. Yes, when it can be? When listing it on 2nd of April, your interim will be continued till next date of listing.
Lordship, I wish to mention for listing of the criminal appeal on 12.
Make a mention before court number 8. Court number 8.
Punishment is no, punishment is only 1 year. That's why.
Court number 8. Make a mention before court number 8.
Wait, please, Your Lordship. Your Lordship, item number 29. In this case, CD was called for. But the CD is not available. Item 29, daily list.
Yes, what about it? Are you on interim there?
I'm entering, Your Lordship.
Issue reminder, CD not received.
29.
Continue till next date of listing. List that record will be on. 2-4 will do. What a code? Doboka. First. First is a working day.
Second,
1st of April.
deeply flushed.
May I please your lordship, I beg to mention item number 15. Lordship,
1-5.
yes, up to date CD was called for but has not been received.
When this it is a criminal petition. We need the updated one.
Yes.
You are MS?
A Chatya.
Hard MS AH Alia, the learning council for petition. Hard report. Learning additional PP appearing on behalf of state response. This submitted by Mr. Board. CD receipt but updated case diary to be returned. In view of this, let the CD be returned. Calling for updated one. And list. Yes, portable when it can be.
Lordship, can it be after 5th of April?
After 5th of April. 7th of April.
Much obliged.
May it please your lordship, item number 48, I am for the petitioner. My senior counsel, he have due to some personal problem, he could not appear before this honorable court. So kindly,
Item 48.
yes, Your Honor.
You're for the petitioner or for the respondent?
I am for the petitioner.
Lordship, I am for the respondent number 2.
You're for the respondent number 2.
Your Lordship, the other side will consent, so kindly the matter will be adjourned for the today.
Lordship, can it be on 30th of March?
3-0.
30.
With the concept of the other side, the learned counsel appearing for the petition. Appearing for an adjournment prayer allowed. Estimate recording 3-0. 30th of March, 3-0.
Yes.
Highly obliged.
Lordship, I beg to mention item number 39. The case diary is not received.
Yes, what is the position of 39? What happened?
39 case diary is stick matter. Case 39 is the case number 5 of
39 is along with 5. 39 is along with 5. Yes, CD received. What to say?
I'll confirm with my senior.
Okay, get it.
Lordship, I beg to mention an IA for listing error.
Make a mention before court number 8. Court number 8.
This is a correction of order, Your Lordship.
So
This
whatever
honor-
we are not allowing the mention matter, you make a mention before, either before AST also you can make a mention. It can be listed before this court only, but make a mention before AST.
Maybe Lordship. Item number 35, Lordship. Case diary not received, Lordship. 35. I'm no interim, Lordship. Only short dates from Bayhada Shaheen, Lordship.
35 is,
35.
you are not on
Not
interim.
interim, Lordship. From Bayhada Shaheen.
City not received, issue reminder. Yes, what? Paribane, আমি 18 পারি।
CD along with my lord,
Just a second, Paribane 18. Okay,
along with injury report, Lordship.
injury report. The issue reminder for CD along with the injury report. We start 18, interim 98.
Obliged.
May please Lordship, back to item number 41. CD not received and there is no interim. So short date may be given. Is it Dispur police
You
station?
are not on interim.
Not on interim, Lordship.
CD not received, issue reminder. Yes, it is from Dispur, Botakot.
18.
18 to
Lordship.
May it please your lordship. Lordship, this is a regular bill, 18 days today. Lordship has probably remember lordship on Thursday, lordship has granted the bail to all the accused lordship. The police person and in civil dress lordship picked up a person lordship, Baharul lordship. I place all the order lordship. Yes. I'm not Baharul, it's a Sheikh Farid lordship. Injury was simple, that is. Paragraph 6 reflect.
your this petitioner is arrested on when?
22 lordship. Today 18 days lordship. Others are all granted lordship. Anticipatory and regular bill that was considered by this court. I have annexed, I have supplied all the copy lordship.
CD is not before us now.
Yes, not otherwise, other accused persons were granted bail after perusal of the case diary.
Only on parity lordship, since on already 18 days and other cases also lordship is granted.
Injury report was
Please.
produced on the last occasion.
Yes, ma'am.
It was simple injury, but
Simple
yes,
injury
the police
by-
personnel came in a civil dress, so incident had happened.
Yes.
I remember. But the involvement of the present petitioner, we cannot say at this stage.
Yes.
Allegation against Lordship Baharul Islam. That person was arrested subsequently, Lordship. That reflected on page 17, Lordship FIR. That person, Lordship, raised hue and cry, and this local people, Lordship, their Lordship. Since police, Lordship, didn't shows their identity card, Lordship, that is the case, Lordship. Considering the length of detention, Lordship, since other are granted, Lordship,
Item number, কোনো license এর মাধ্যমে দিয়ে দিলাম। Wait for that. How many petitions are here?
here one petitioner, Lordship.
মানে নাম সব হলো না। এটা না লাগে 3 নম্বর 2 এটা না লাগে সিটি টু নাই আমি মিস্টার ছোটরি সাবমিশন দিব আর 5 নম্বর প্যারা তো 5 নম্বর প্যারা present petitioner got arrested in connection with this case on 22/02/2025. He is not on interim.
Pardon, Lordship.
He is not on interim.
No, Lordship.
And 25 and does the Iowa section opportunity to interrogate a petitioner, keeping him in custody. No. That is sir. And further he submitted that the accused petitioner being the local resident of the address permanent resident of this address locality will appear before the IO as and when his cooperation with the further he submitted that all the co-accused petitioners are already granted bail. And considering the case of the present petitioner on the same footing, his prayer also may be considered. Next paragraph, submission number para number 6 to the Mr. Porter for declared edition be submitted in this regard. That from the allegation made in the FIR, it's seen that the present petitioner along with some other persons have attacked the police person who visited to the place of occurrence in civil dress in a private vehicle only to maintain secrecy. However, he submitted on the last occasion the CD was produced, wherefrom it is seen that the one police person also sustained minor injuries. However, Mr. Porter raised objection and submitted that CD may be required to know the involvement of the presentation. It will highlight everything. So, 8 number 2 considering the submission made by Land Council for Proceedings, and also considering the bail orders submitted by the Land Council for the petition, considered for the other accused persons. I find that further custody interrogation may not be required for the interest of the investigation. In view of this, 9 number prayer to nalage, 10 number prayer to give. Well, 10 number prayer to share, yeah, bail the difficult. The absolute for us, yeah, the bail. Our satisfaction, the other good advance to us. Okay.
I lay obliged.
Lordship, the matter may be taken up after some time, Your Lordship.
Item number 2.
Yes. Obliged.
Item number 3, along with item number 21. My lord, 3 may kindly be taken up along with 21, my lord. 21
Yes.
cases. If there is
Oh, along with 21.
21.
Okay.
I'm present for 20. For 20.
Item number
When 21 will be called.
Okay.
Lordship, may I please, Lordship, actually, I'm extremely unwell. I'll not be able to wait till the item, till my
Yes,
turn.
he has gone for the city then.
In that case, Mr. Sharma, you'll be able to? Oh, who is, that's his spirit. Cheer. Let's come first 21 because it will be, CD was called for that. Yes, what is 21? Yes, explain.
Lordship will find the FIR at page 8, Lordship. May I read, Lordship?
Page 8.
Yes, Lordship, may I read? I hereby lodge a complaint that on 31st of January 2026 at around 9:30 p.m., a fight broke up at Bamuni Moidan. Anupam Boro went to the spot to intervene and mediate between the parties involved. However, two individuals, Ujon Chakma and Rahul Gurung, attacked Anupam Boro. He has been severely assaulted by the accused and ended fracturing his left leg with a sharp object, iron rod. Therefore, so and so, Lordship. Lordship may now kindly turn to page Annexure 4, Lordship, page 19, Lordship, which is the medical document of Anupam Boro, the last page of the petition, Lordship. Lordship has found. Lordship, in that medical document, Lordship may kindly see that it is clearly being reflected in the medical document that it is a case of RTA, Lordship, road traffic accident, Lordship, that took place on the alleged date of incident, Lordship. Therefore, Lordship, this FIR has been lodged in a very frivolous manner against the petitioner, Lordship. And also a thing may be noticed, Lordship, that the date of incident was on 31st of January 2026. However, the FIR was lodged on 2nd of February 2026. There is a delay of 2 days, Lordship. However, no such reason of delay is mentioned in the FIR. Moreover, the informant who has lodged the FIR, that is Meghali Rai, she was not even present at the place of occurrence, Lordship. Completely an afterthought FIR that has been lodged against the petitioner, Lordship. So at this stage, Lordship may kindly allow the petitioner to go and bail. As of today, it is 35 days behind bar.
Yes.
Yes, Lordship. If I look into the injury report state it is type of injury is grievous, Lordship. Grievous injury is there. And if I looked into the statement of the victim, Lordship, these two persons are there. And this person, this Ujjain, this Ujjan Chakma, that is item number 3. He is also present, and Rahul Gurung, they are also present. And they fight with this person. It is stated in the victim statement.
No, but whether SC submitted that, was it a RTA?
Regarding that, Lordship, stated.
It is itself mentioned in the medical document of the victim.
Then I have
Anupam
need some time, Lordship, because I have I was trying to read that whole CD, Lordship, but I have read only this part. After some time, Lordship, 5 to 10 minutes.
No,
I will go through.
only from one medical document, she
Lord-
is saying that it was an RTA. You
But-
just peruse the injury report, whether is there any note?
Lordship. That is why I need 5 minutes, Lordship, only after 5 minutes. Okay, Lord.
My pleasure, Lordship. Lordship, this is regular bail application, Lordship. In this case, Lordship, my limited submission, Lordship, the out of same FIR and same forwarding report, Lordship, the co-accused already been grant bail, Lordship, and this order will find page number 24, Lordship. And only on the ground that, Lordship, the 48 notice was not communicated to the family members of the accused person. And Lordship, here in this case, the kindly for a moment, Lordship, page number 22, Lordship, is the WT message, Lordship. And Lordship, the petitioner number 2, Lordship, and he is residing under the Soigao PS, Lordship, in Kamrup district, Lordship. But the WT message sent by Gorsik police to the Lakhimpur police station, Lordship. Another 2 accused, they are residing at Lakhimpur, Lordship.
And so, my lord, one thing is very much clear, lordship, though no communicate to the family members or other relatives of the accused, lordship. Well, on that basis, lordship, the co-accused already been done. Similarly, putting out of same FIR, same forwarding. Page number 24 is the order
We have
passed by
considered
law.
only length of detention.
Length of detention.
We are other prayer we have not considered.
Out of same FIR, same forwarding. lordship.
No, same forwarding.
Same forwarding. Same forwarding. And
When
similar
your
putting
petitioner got
there,
arrested,
lordship, under there, 19-1 lordship.
19.
And as on today, lordship, 49 days. So all 3 persons, they are sitting in the dhaba, lordship, and suddenly police appeared and picked up them, lordship. But one bolero vehicle is found in front of the dhaba, and some fake gold and gold.
No, your petitioner is not from North Lakhimpur.
No, one is Lakhimpur, not Lakhimpur, and another is from Soigaon, lordship. Kamrup.
No, your present petitioner is from Soigaon.
No, one is Lakhimpur and one is Soigaon. Two petitioner, lordship. Petitioner number 2 is Soigaon. So length of detention may be out of same forwarding, lordship. Similar putting, lordship. Nothing has been recovered from them. One vehicle is parked in front of the dhaba, and from the vehicle, lordship, and that is from one Islam Ali, is the register owner of the vehicle.
Yes, Port Harcourt, we are only last
Yes.
occasion we have produced the case diary there.
Yes, ma'am. 3 persons were
3
apprehended.
persons were apprehended.
Guljar Hussain was granted bail, my lord, and from the vehicle which was in possession of all these accused persons at that point of time, my lord, those fake currencies and my lord, one fake gold was recovered. And thereafter, only on the ground of length of the detention, your lordship has granted bail to Guljar Hussain.
Because we observed that the police took this stage because from the OC Korsuk it was sent to North Lakhimpur.
Yes, ma'am.
Thereafter, as you have submitted, there are no such communication as to whether they have
Yes.
received or not.
Yes, yes.
But on the other hand, it is seen that what is the purpose of sending the notice? Notice is sending is the purpose to
Yes.
arrange the bailer for bail petition,
Yes,
doing
ma'am.
of this kind of things.
Yes,
But here too, they have already moved. That observation I have made.
yes, yes.
And only considering the
So
length
only
of
considering
detention
length of
already
detention,
it is
ultimately,
gone.
your
And
lordship.
if it is the same forwarding,
Same
then definitely
forwarding,
it has to.
same.
Heard Mr. F. Hope did also for the petition. Also heard Mr. P. Water for the non-judicial PP agreeing on behalf of state respondent. This is an application under section so and so, connection with so and so. Next, it is submitted by Mr. Hope, the Ghana Council to represent the petition that to DD board. At post page number 25, para number 4 to DD board. Section 5 to do over it. Number 20. Six and a half. Mr. Waterford, the granted additional PP submitted in this report that though the case diary is not available before this court, but on perusal of the order passed earlier for the other co-accused persons, it is seen that these 2 petitioners along with the co-accused persons were traveling by the said vehicle, where from the fake currencies of near about 99,000 and fake gold weighing 1.39 were recovered. তাৰপিছত বাকীখিনি মই এতিয়া মাৰ্ক কৰি দিছো পেয়াৰ নম্বৰ 6 এইখিনি একেই দিব পাৰোঁ এইখিনি একেই দিব মই এতিয়া মাৰ্ক কৰি দিছো মিষ্টাৰ হকৰ সাবমিশনটো দিছে যে মিষ্টাৰ হকৰ সাবমিশনটো 5 পেৰালৈকে আছেতো সৰু এটা পেৰা ইয়াতে এড কৰি দিব Mr. Hawk, the learned counsel, petitioner further submitted that the one of the co-accused petitioner has already granted bail by this court, and hence, considering the case of the present petitioner in the same sitting, his prayer may also be considered. However, the petitioner being the permanent resident of his address locality, he will appear before the learned trial court below, appear before the IO as and when it will be required. Episode 7 number on with the SO. Hearing the submission made by learned counsel for both sides. This seen that on the earlier occasion, while considering the bail application for the co-accused person, the materials were considered available in the case diary. And considering the case of the present petitioner in the same footing as these two petitioners were also forwarded under the same forwarding postal. Thus, without going the further detail into the merit of the case, only considering the length of detention already undergone by the accused petitioners. This court is of opinion that IO got sufficient opportunity to interrogate these two petitioners, keeping them in custody, and hence considering the length of detention. I find that further custodial interrogation may not be required for the purpose of investigation. Accordingly, I find it a fit case to grant the privilege of previous bail to privilege of bail to these petitions. Okay.
Deeply obliged, Lordship. Deeply obliged. Obliged.
Supplementary, if you want.
May I please, Lordship?
Item number 51, although my lord listed for motion, my lord. Actually, in this matter, earlier CD was called for, man.
Oh,
So,
CD has not yet called for Lordship. Whatever Lordship, out of the same incident, 2 FIR has been lost by 2 different persons. In one case, Lordship, another case, the petitioner was arrested. And in the instant case, Lordship, he has been soon arrested. And that bail application was moved yesterday and matter has been fixed on 16/3, Lordship. Your Lordship may call for the CD and let the matter be fixed on 16/3.
along with
Along with, yes, Lordship, BA number BA 492/2026.
492.
26. 492.
BA क्यों? B2.
492.
Mr. M, the learned counsel for the petition. So had Mr. P. Bot, so and so. CDB call for BSD matter according, BSD matter on 16/3/2026, along with BA number 492 of the total.
Obliged.
Item number 5, along with item number 39.
Please, Your Honor.
5 plus 39.
Honor, I'm for item number 5, Your Honor.
This matter may kindly taken up along with 39, my lord. Case diary received, my lord.
39. And in 39, you are not appearing?
No.
Who is for 39? Oh, Hari Waterpool. She had
CD
in
received.
morning hours. Yes,
Yes.
when you said that CD received, and she said that I'll just take it
Yes,
from.
after
Now
getting
she is not
instruction
here.
from her senior, my lord, he will,
Ah.
so let the matter may come up at the time of polling item number 39.
Okay. And it's 39 কাৰ লগত 5 ৰ লগত.
May I please, your lordship? Lordship, there's a matter under 329-4-109-1182 and 35 of the BNS. Lordship, we have a very limited prayer here in this case. Your lordship, the charge sheet has already been submitted with regard to this matter. And we are praying for an interim anticipatory bail in this instant matter because it's fixed for appearance on 17/3/2026. That is in a matter of week. Now, lordship, may I kindly peruse page number 4, that is para 7, that we have stated in our complaint petition, page number 4, para 7,
that during the investigation stage of the case, as no bail was granted to the accused persons petitioners by any court, and as such they submitted bail petitions wherein one anticipatory interim bail was granted, and as such they appeared before the IO. But it was mentioned in the case diary that the accused persons neither appeared nor followed the honorable court's order after informing several times to appear, and as such the interim bail of petitioners were cancelled. Thereafter, the IO submitted charge sheet showing them as absconder without following the due procedure, Your Lordship. They have not followed any procedures laid down in the law, and trial court issued summons to the accused person and fixed 29/12/2025 for appearance. But the accused person's petitioners had taken steps for adjournment and prayed another date as they had genuine apprehension that they would not be enlarged or brayed by the learned trial court. The next matter is fixed on 17/3/2026. It is pertinent to mention herein that the accused petitioners applied for anticipatory bail before the district and sessions judge, which was rejected, Your Honor. And it was directed, that is on page 27, Your Lordship, that in 26 last para, page 26 last para, annexure 3, accused persons Mukhtar Hussain and Mubarak Hussain are directed to appear before the learned Elaka magistrate within 7 days from today and file prayers for regular bail. Then the next page, Your Honor, that is on page 27. In event of filing of such bail prayers, the learned Elaka magistrate shall consider the same as per law. Your Lordship, now having no other remedy, we have appeared in before this honorable court because the learned Elaka magistrate doesn't have the power to try a matter under section, under section 109, which has life imprisonment in it, Your Lordship. We are for the fact that a very limited prayer, Lordship, since the matter is fixed in 17/3, that is in a week. The accused persons will go and appear before the honorable court, and with regard to the scope of interim anticipatory bail, Your Lordship, I am placing a judgment that I've given in the book list. That is Sushila Agarwal versus State NCT of Delhi. 91. No? Or 91. Your Lordship, in this particular case at page 109, that is para 91.2. As regards the second question referred to this court, it is held that the life or duration of an anticipatory bail order does not end normally at the time and stage when the accused is summoned by the court or when charges are framed, but can continue till the end of the trial. Again, if there are any special or peculiar features necessitating the court to limit the tenure of anticipatory bail, it is open for it to do so. Your Lordship, so there is no bar by the law that the anticipatory bail can't be granted at this stage. We are praying till the case has been commuted. We are praying for an interim anticipatory application because the accused persons are ready to cooperate with the trial. On top of that, charge sheet has already been filed and investigation has been completed. And there are many judgments which say that no further detention of a person is necessary when a charge sheet has been filed. So it's a limited prayer to allow both the, before Your Lordship, to allow both the persons to go out on anticipatory bail, Your Lordship.
Well, first of all, well, initially during investigation, interim bail was granted.
That's what I'm saying, yes.
Thereafter,
They're
well, after
see the conduct of the
yes, well,
activity.
conduct. Well,
They
after
not even
obtaining
appeared before the IO.
IO.
For that reason only the interim had to be cancelled by the
cancel, yes, well.
Since such a cases, it
Yes.
cannot be.
And because of that, later on, well, declared as absconder in
Yes,
the,
obviously.
shown as absconder in this section.
Because their prayer was considered, interim was granted,
Yes,
and then they did not appear.
it did not appear.
Your Lordship, they appeared before the
We are
learned.
calling for the scanned copy of the TCR at present. Your case is petitioner case is fixed on 17/3.
Yes, sir.
But prior to that, it has to come from which place?
Dhula, Dorong.
Dorong Hula. 0.5. Scan copy help. Detail 16 or 17. So Botaku, their case is on fixed on 17th. We have called for the case diary also. In that case, I mean, scan copy of this TCR along with TCB.
17, they can take adjournment there, well, otherwise on before 17, well,
Your Honor,
Whether
they all,
appeal will come
your
on
lordship, adjournment was already
16th of
taking on the previous
16
date, your lordship.
16th of March. If not comes, well, after 17, well, on 17 they can take adjournment. Well, on
We
17
don't
they
have
can,
any 13th with possibility is
on
less.
17 they can take
14th, 15th
adjournment
is
later on.
holiday. 16th, even if suppose it comes, at best 16 can be, otherwise we don't have any.
Yes. Otherwise, after 17th, my lord, they can take adjournment on that day. My lord.
If the court makes an
Otherwise, till
observation,
now, he has not appeared before the trial court. There is no
Never appeared.
person. Never appeared.
they are apprehending arrest,
Till
your
now,
lordship.
my lord, he is fleeing from justice. Then also, my lord, till 17, then thereafter also. On 20, on 18, 23, 20th of March.
23 will do.
23 will do, your honor, your lordship, but your lordship might kindly allow the interim bail till then.
Your conduct doesn't allow you to.
This time it won't happen, your lordship. We are going for.
This is a court case. It's not a case of a thing of many. That this
Then
time we'll do, this
your
time that
lordship
will
might kindly, it's a humble prayer that the court might allow adjournment on the 17th, so that we can.
You can pray for. You can pray for.
Otherwise,
it, John.
till now, he has not appeared. Let him file an application before the trial court. Without his appearance, my lord, ultimately, my lord.
So, committal case committing is we also be. At best, we can give on 16, but I don't know if suppose in any reason your 16, your order may not be uploaded for due to many reasons. In that case, it will be again a problem.
Yes. 23, 3 mile on that day.
23,
we'll get
okay, we'll see. You take an adjournment on that. 23. Registry will do this. Can copy of the TC along with the case diary. Registry will do the needful. List on 23. Okay. We're listing it on 23. 23rd of March.
Oblige you.
May I please your lordship?
Yes.
Lordship, this is an application under section 482. FIR page number 9, lordship. May I read, lordship?
Short sheeted case. my lord.
The girl died. She died.
Yes,
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 ma'am.
lordship.
Expired.
Abatement of suicide, lordship. But lordship, at the time of incident, petition was not there in Kerala. But lordship, due to failure of love relationship.
No, these are the matter of your the married. If case is already charged, is so married will not. It's so at that time, at this time.
So due to failure of love relationship, that's why the incident was happened.
Now.
So
She
already
already-
lordship
she
matter
already
started
died, na?
investigation.
She already died.
Lordship investigation already.
Have you
closed.
annexed any order sheet here?
No, lordship.
Order sheets have you annexed?
No, lordship.
Is it charge sheeted case? Why you have not annexed any order sheets? Where from we'll know now? What is the position of this case? Whether someone issued, whether
Yes.
warrant issued? How can we know?
Already lordship someone issued, but I have not annexed.
You have not annexed anything. Even if suppose interim relief may be granted, but you're not submitted anything yet. How it can be? We're listing it on. So next date, can you tell us?
Lordship.
Your next date, can you tell us?
Yes, lordship.
When?
Lordship 2025.
25
May
March.
20.
May 20.
May 20.
The earlier date. Which court had been given?
CGM Nagaon.
Which court? Otherwise, the penalty is quite
Yes.
high, is there? Still, month of May is given. Then 23, 24, what are they given? 20, 24. No, they only additional hearing on the 25. We're listing it on 25/3, simple listing. We're not mentioning anything. On that day, you just file all the order sheets through an additional affidavit. Okay. Because here nothing is there. We cannot say anything.
Yes, you know, may I scan copy of PCR?
In the meantime.
Yes, yes.
Okay, in the meantime. No, you can't like scan copy of the PCR along with the case verification.
Lordship, pre-arrest bail application, my lord. I don't know whether any FIR has been registered or not, but I have been receiving frequent calls from Patasil Ambari police station, my lord, to appear before the police station, my lord.
Do you
The fact is-
have any case of kind of thing for apprehension or apprehending that this matter may be lost in a court joint?
My lord, actually what happened, my lord, there is a dispute between me and my wife, and my wife and my mother-in-law, along with sister-in-law, they have assaulted me. I have lost also an affair, my lord.
You have
That is
already lost.
Yes, yes, my lord. At page number 8, my lord. And I apprehend that in retaliation, my lord, only they have filed some FIR, my lord, against me, my lord. And they have also obtained anticipatory bail, my lord, at page number 21, my lord. So,
Right. When your police visited to your place?
my lord, I not visited. I have been receiving phone calls, my lord. And somehow I came to know that JD entry has also been made here, lordship.
GD entry already made?
My lord, I have mentioned in my course title, my lord, bottom, JD entry number 22 dated 15 to 26.
GD entry has already been made.
As per my information, my lord. Yes. So that's why I have been apprehending, my lord. So let me appear before the officer in charge, my lord. In the meantime, my lord, and a report may be called from the police station. My lord.
Yes, Mr. Kotasilambari.
Yes, I will get the report.
Heard Mr. H. Ali Dilan, counsel for the petitioner, and also heard Mr. P. Waterco, Dilan, additional PP, appearing on behalf of state respondent. This is an application under section 482 PNSS, paying for anticipatory bill. Apprehending arrest in connection with any case to be registered may be raised, would be in any case of any case to be registered under Fakasil Ambari Police. It is submitted that next right submitted by Mr. Ali that the present petitioner earlier lodged an FIR against his wife, sister-in-law, and the relative of his wife, which has already been registered as Palpan Bazar PS case number 357 of 25, wherein they also obtained interim pre-arrest bail poster. But in retaliation, they may approach the police station of Farasil Ambari against the present petitioner, and to that regard, he already received a phone call from Farasil Ambari police station. From the reliable sources, it is also learned that one GD entry has already been made under Farasil Ambari PS case BS GD number 22 dated 15/02/2026. In view of this, Mr. Ali submitted that interim protection may be provided to the present petitioner till receipt of the report. Next, Mr. Porter Kodilana, the additional PP submitted in this that he will call for a report from the concerned police station as to whether any case has been registered against the present petitioner under Farasil Ambari, the case registered against the present petitioner or not. In view of this, let a detailed report be called for from Farasil Ambari PS, and in the same time till the receipt of return report, the police of the from the Patasil Ambari PS is hereby directed not to take any coercive action against the present petition. List the matter when it can be listed. But
Yes, my lord, on 22nd of March. 22nd is holiday, on 23rd of March.
23rd.
Obligation.
Item number 3 and 21.
Yes, you're saying that these two petitioners were present there and the injury is also grievous in nature.
Lot,
But
yeah.
one submission she made that as per the medical report, it was an RTA.
Lordship.
Whether that is there.
Oh, yeah, what I have seen, Lordship, I have stated, seen the statements of the victim and other witnesses. And according to it, Lordship, it is not a road accident, Lordship. And moreover, these two documents, what the petitioner have annexed here, I have not found in the CD, Lordship,
Oh,
first of all. Then, Lordship, what had happened, Lordship, these two persons, this Ujan Chakma, that is petitioner item number 3.
Hmm.
3 and with another person, that is Surot. They have a fight regarding some girlfriend issue, Lordship. And on that, they fight on a road, Lordship. And this person, this Rahul Gurung, Lordship, the item number that is 21, no?
Yes.
Item number 21. He suggests that to this person, item number 3, Lordship, that let's go to that person and fight with them. Surot. But this person, the victim, the injured person, came in the middle of this fight, Lordship, and he tried to stop that fight, Lordship. But in the meantime, both of them struck this person. And they are also in a drunken state, Lordship. They have also stated that they are in drunken state. The whole thing is that, Lordship. The road accident does not come.
Doctor, this is the certified copy that we have applied for.
That
From
may-
the certified
but-
copy from the court.
But I
we
have not
seen.
found the CD in the CD, it is not there. And from the circumstances, what I have seen, Lordship, from the victim and these witnesses, it does not seem like it is a road accident, Lordship.
If so and so incident would have occurred, then they must have lodged the FIR on the date of occurrence itself, Lordship. And this is not a document that I have lamely produced. This is the certified copy that I've obtained from the Honorable Season Court, Lordship. It is a certified copy that I've obtained.
Lordship may
it's
pass,
not available.
Lordship, it is not there. Lordship may look into the CD and pass appropriate order. But I have not found, Lordship.
21 to
May I please, Lordship? Lordship,
And moreover, two things, Lordship. These two persons are one from Meghalaya and another is from Mizoram, Lordship. So they may fled away, Lordship.
may I please, Lordship, with due permission, Lordship? The occurrence took on 31 January 2026. On that day, it occurred 9:30 p.m. After that, Lordship, when the incident occurred, the random people approached there. After that, they called the police, and the police came. And the Uzan Chakma, Uzan and Rahul were just nearby the place only. So at the time, the police arrested around 5 persons, Lordship, on the day itself, around 5 persons. So later they took him to the police station, Lordship, and they medically also check up. On 1st February 2026. There is not on record, your Lordship. After that, your Lordship, they released from the police station around 1:30 a.m. on 1st February, Lordship. That is not on record, Lordship. So with the conditions, they released that to approach to the police station whenever they call for, with the conditions. So what happened after that? On 2nd February, Lordship, around 6:30, the investigating officer call up to the accused persons. So they went to the police station again by the accused Uzon and his friend, his colleague, around 5 persons, Lordship. So after that, Lordship, around 6:30, they detained, Lordship. 6:30 on 2nd February 2026, Lordship. Thereafter, Lordship, since the fight broke out between Uzan, the accused Uzan, Me and the Surat Chakma one. He was not arrested, Lordship.
Fight?
I don't know, Lordship.
No, fight took place between Ujan.
Ujan and the Surat Chakma, girlfriend is Lordship. So after that, Lordship, since the fight broke out between the Ujan and the Surat, so the Anupam Bora, the victim, who is a friend of Surat Chakma, Lordship. So even the accused Rahul or the accused Ujan, they didn't know who is Anupam Bora, Lordship, at that point of time, Lordship. So when after the fight broke out, then since victim and the Surat Chakma, they were a friend, Lordship. So the Surat Chakma started to the Anupam
But
Bora.
Ujan and Surat Chakma were fighting.
Yes, your Lordship. Instead of arresting to the other Lordship, they arrested to the innocent Lordship. Lordship.
How you are innocent? You are involved in fighting also.
Yes, Lordship, I am admitted, Lordship, but Lordship, considering into the long detention, Lordship, I'm 36 days today, Lordship. I'm a student, Lordship, and my father is a Assam Rifle, so is guarding the country, Lordship. It's in India and the China border, Lordship. I have one mother, Lordship, to take care of, Lordship, who is a heart patient also, Lordship. And I mean, my class is going on,
Indulge
Lordship.
yourself with such kind of activities. With a girlfriend issue, why you're fighting with the others? For a girlfriend only, you fight with the other one, Suraj, isn't it?
Surat Chakma, yes.
So you are behind the bars since 35 days.
36 today, till today, Lordship. Date of arrest is on 3rd February, Lordship.
20, item number 21 also, the length of detention is 36 days.
You are Mr. B. Chand.
Baplu Chakma, Lordship. My name is wrongly reflected there, B. Chanda, Lordship. It should be BAPLU, CHKM, as per in the Baklat name also, Lordship. PLU, BAPLU. Baplu Chakma, Lordship. Yes, Lordship.
You have already filed your Vakalatnama.
Yes, Lordship. It's there, yes.
Heard Mr. P. Chakma. Number 3. A learned counsel for the petition. So heard Mr. A. Keta, learned petition, which we have paid on the it's an application in the section so and so. There is receipt which has already been received in connection with DL application number 585. Next part is submitted by Mr. Chakma, the learned counsel for the petition, that the present accused petitioner is innocent. He has not committed any such offense as a reason there. He does not even know, said Anupam, who is stated to be the victim of this case. However, it is a fact that he had a fight with one Suraj Chakma for a girlfriend issue, on issue of a girlfriend. But thereafter, someone had reported police and police came. And him along with one on the day night of 31st January 2026, but thereafter at about 1:30 p.m. 1:30 a.m. on the 1st of February, they were released from the police station, asking them to appear as and when it is. But on 2nd of February 2026, at about 6:30 p.m., police came to their place and arrested the present petitioner. He further submitted that he has no connection with the victim Anupam, who and he had only fight with said Suraj, has no other issue, and has no other enmity with said Anupam. However, he submitted that he is in custody since last 36 days, and hence, considering his length of detention, he may be released on bail. Next, Mr. Das Dilanet additional PP raised objection and submitted that there are sufficient incriminating materials against this petitioner also, who initially had a fight with one Suraj Sharma, but thereafter, when the victim came and tried to stop the quarrel, this accused person, along with some others, had assaulted the victim, for which he sustained previous injury on his person. Mr. Thus further submitted that the present accused petitioner belongs to which place?
Lordship.
Chakma is belongs to which place?
Or it belongs to Lordship, Mizoram Lordship.
Mizoram.
Mizoram.
Lordship, Mizoram, permanent is Mizoram Lordship and presently in Garchuk Lordship. They have house there in Garchuk also Lordship.
No, they is from Mizoram, and hence the probability of absconding also cannot be denied at this stage. Accordingly, Mr. Das raised objection.
And Rahul is also from Meghalaya.
It will take you hearing in absolute hearing the submission made by counsel for good sense. I have perused the case record, and it is found that the victim sustained previous injury on his person due to attack by the accused persons. However, it is the fact that the present petitioner had no intimacy with said Anupam, who only came to stop the quarrel between these two persons. The present petitioner, not these two, like the present petitioner, along with one Suraj Chakma. But at the same time, it is also seen that the accused petitioner is in custody since last 36 days, and hence, not without going further detail into the merit of the case, and that I got sufficient opportunity to interrogate the present petitioner, giving him in custody. But from the consideration made by, but from the submission made by learned additional PP, it is also seen that the accused petitioner belongs to state of Mizoram, and hence some strict conditions of bail has to be applied for, given, so that his attendance may be procured during investigation as well as during trial of the case. Taken a 2 security করে দিব 50,000 দিব 2 security দিব 1 government security number হেৰি 2 question number 2 আর চেঞ্জ করে দিব why yes we need it MS SCSB Legal Counsel for Swans. It is submitted by her that the present accused petitioner is innocent, that he has not committed any such offense as alleged in the FIR. Is the fact that there was a quarrel between one Suraj Chakma and one Suraj Chakma and one Ujan Chakma for a girlfriend, but this petitioner has no role in this seat fight. Further, she submitted that she obtained a certified copy of the certified copy of the injury report of the victim Anupam, wherefrom it is said that it was an RTA which had happened on 31st January at about 9:30 p.m. She further submitted that the accused petitioner is in custody since last 36 days, and hence, considering his detention also, the petitioner may be released on bail. He is a permanent resident of his address locality and will extend his cooperation as and when it will be required. Next paragraph. Mr. Das, still an additional PP submitted in this regard, that the present petitioner was very much involved in the alleged offense, and at the place of occurrence, this petitioner is also present along with the others. However, he submitted that initially a fight took place between one of the co-accused Uzan Sakma and Suraj Sakma for a girlfriend. But when the victim tried to stop the court between them, the present petitioner was also involved, assaulted the victim, for which he sustained grievous injury on his person. Mr. Das further submitted that the present petitioner also hails from Meghalaya. Na? Meghalaya, and hence the chances of absconding also cannot be denied at this stage. Working more submission to appeal. To that condition, it was here to declare. It's to the satisfaction of the association. Okay, these two petitions are granted bail, but there will be some conditions.
Deeply obliged. Much obliged.
Item number, I would like to point out item number 27, my lord, that was adjourned in the morning.
27. 27 was adjourned, yes.
Adjourned, my lord. That in that case, my lord, earlier since matter is pending since 5/12/25. In this case, my lord, one report from Iowa was called for whether any case is pending or registered against the present petitioner. But my lord, while later on I have gone through the my lord petition, my lord, in that is a search-sheeted case. And search-sheeted case, my lord, actually my lord petitioner search sheet submitted against the present petitioner.
Oh.
And now the petitioner has disputed his identity. In fact, summons also issued against the petitioner. So now how can police submit a report, my lord, whether any case pending against the petitioner or not, my lord? So regarding that aspect, my lord, I will like to point out, my lord, he will have to, my lord, if anyway he is aggrieved, then he will have to, my lord, approach before the trial court, my lord.
But the counsel, who was the counsel? He is already gone.
Your lordship may
But
kindly
I
fix
did
this
not-
matter, my lord. Otherwise matter is, my lord, unnecessarily pending since long. Police also cannot provide any report in that case. If possible, my lord, your lordship may kindly fix the matter tomorrow or day after tomorrow.
He was here, na?
Yes.
He talked to him.
Yes, yes, I will,
So you can just inform him, it can, if it can be fixed on tomorrow also.
tomorrow. Yes, your lordship may come up in the supplementary list, man.
May come up in a supplementary
I will
list.
point out to him.
But inform.
I will inform him.
Kun advocate asle ba pahari golo.
I will inform him, my lord. Even file is also here, man.
Okay then. Okay.
I will.
এইটো কোনে লৈছে শৰ্মিলাই লৈছে কালি কাৰণে কৰি দিব দিয়ক আপডেট আহিব কালি কিমান তাৰিখ 11 কৰি থৈ দিব just you can just inform him about it.
Yes, yes.
Lord, may I brief your lordship
Item number
indulgence?
17.
No, my lord. I am appearing in item number 13, 13, my lord.
1-3.
1-3. My lord, can that matter be taken up at 2 p.m., my lord?
Now at this stage, I cannot say because we have a division bench matter. Matter may not take so much of time.
Then
Division bench
after your
matter, I
lordship,
cannot say.
after your lordship seat again up in the second half, can that matter be taken up then?
No, we cannot say that it will be taken up at 2 because there are many bail matters are also there. If it can be completed, then definitely I can take. Your item number is 13, na?
13,
We'll
one.
give a star mark here. We are just keeping it.
Yes, madam.
And let us see if it can be. I can.
I'm being called to some other court today. Some of my colleagues are also not
Oh,
here.
you can leave.
Fine.
No issue.
I'm with
17. That hawk asile dabei.
16, 17.
16
Mr. Hawk was there. Mr. Hawk was earlier there. What is the position of
17 case they received.
Mr. Hawk was also available there. Now at the time he is not here. I don't know.
Yes.
I what to say.
Yes, madam.
No, what to do, Miss? Otherwise, Mr. Hawk was here. Most probably he has gone to some other court.
Yes. After some time, madam.
Okay.
After time.
And depending.
Yes.
May it please
Therefore,
your
in the
lordship.
position of 18, CD receipt.
Lordship, here lordship. Petitioner is in custody for last 38 days since from 5-2. And the lordship would be pleased to see the affair at page 15.
He is in custody since 5-2.
5 to 38 days, lordship. And here mandatorily 35(3) notices mandatory lordship in this sort of affair. Lordship, page 15. Before that, before placing the affair, lordship, the fact of the case in gist is petitioner happens to be a businessman dealing with the garments supply of a school uniform in the name of HRA Traders, lordship. Now, he is one of the employee rookie there. He was lending the vehicle, taking the vehicle on hire for and from different parties, even including from a petitioner also. Vehicles been taken and then it was placed under rent. And monthly petitioner and along with others were receiving the monthly rent regularly. But before this incident, I mean, before this affair, lordship, 2-3 months ago, that they stopped paying all the parties, lordship. So unfortunately, lordship, this affair has been lost. That is at page 15, lordship. Now I'm taking the pleadings of the affair, lordship. With due respect, I beg to state the 9/11/2024 1C depends on my so-and-so, son of so-and-so, resident of so-and-so, so-and-so, took my vehicle bearing registration number so-and-so from my house, entering into an agreement with me promising monthly rent of 35,000. He paid the rent for about a year. Thereafter, 11/12/25, he again took my vehicle on from me, promising to pay monthly rent. However, he has not paid the rent till date. Furthermore, he has not provided any information regarding whereabouts my two vehicles. I have come to know Sri Dipan Sharma took two vehicle intention of stealing them, has committed fraud by selling them outside state. Therefore, I request. Now, lordship, pursuant to these two, petitioner on his own recovered and by helping the police, I have on the last occasion, I have placed the Jimma of those two vehicles are available in the record, lordship. So petitioner, by investing his own money, lordship, recovered the vehicle. And meanwhile, petitioner was in custody for police remand for 5 days initially. Therefore, it has again extended to 4 days. So 9 days police custody and thereafter lordship judicial custody. So these two vehicles, along with one more vehicle, lordship would be pleased to find in the record. This is available. Last occasion, it has kept in the record, lordship. Has become I have supplied the certified copy
Where
of
from those were recovered?
petitioner with the petitioner helped, petitioner cooperated, taking
Because he
information.
sold these two vehicles outside the state.
Outside me, it was rent to Pasighat. It was on rent.
Why he rented to Pasighat?
Not he exactly, lordship. He's one of his employee, Rupjit Das. Even he took Rupjit Das, took petitioner's sister's vehicle, petitioner brothers. They all believing that the high value will come in a month, 35,000, 38,000. So that is why I agreed, lordship. And petitioner being part of this HRA trader, he also signed the agreement. Because of signing, his liability came, lordship. And that is why, lordship.
Yes.
So my sole contention, lordship, the vehicle in question, lordship, has already been recovered. He have cooperated with the police, lordship, to every extent, lordship. Even he invested his own money and spent 38 days, lordship. So 60 days maximum period, lordship, 7 years, and that is my submission, lordship. Considering he's a local person, he will cooperate rest part of the investigation. Considering all progress, may I pray that any stringent condition be given for his release on bail at this.
Lordship, if I look into the FIR, it seems like this is a case of such things. One person agreed to made an agreement to get those two cars, lots of vehicles, and he has failed to pay that amount. But if we look into the background, then the real thing will come up, Lordship. What is there in the CD, Lord? It is not that these two vehicles were only in issue, Lordship. There are other persons. Some persons are also there. There are more and more victims are there. During the investigation came up, Lordship. That persons also FIR, lodged an FIR. Regarding the same, there are also vehicles have been rented by these two persons, this person, and he has returned it. And he sold it to other places also, Lordship. And in this regard, Lordship, I also wanted to, 47 and 48 are also there. It has been given. And moreover, Lordship, one prayer was made by the IO, Lordship, for getting the permission during the, may I read few lines, Lordship. During interrogation, the accused persons confessed that the vehicles involved in the case had been recovered from different places outside the state of Assam, Lordship. Namely, so-and-so, Pasighat and Zonai, Assam, other places are there. So I pray, Lordship, this is not a case of single case, Lordship, that what my learned friend trying to depict a picture, Lordship. There is a case of just that he has unable to pay this money, rented money, so, and it has been recovered. It is not that, Lordship. He has taken vehicles from other persons, not returned them back, Lordship, and he has also sold to other places outside Assam, Lordship. And police is investigating also on that count, Lordship. This person's interrogation is necessary because other persons need to be recovered of the vehicles from this person. So it is a racket, Lordship, not a single case, Lordship.
Lordship.
So I objected to this, Lordship.
Lordship, may I take countering to his submission, Lordship? Here, this affair, this Nunmati police station case has been police station case number 21/26 has been registered, wherein petition has taken into custody in connection with the affair lost by this person, Lordship, wherein these two vehicles are in question, Lordship. In respect to this affair, Lordship, now if others are there, Lordship, definitely there will be affair without an affair.
It is necessary because initial
Lordship,
deception has to be taken into consideration, Lordship, because sitting is there. So initial deception has to be taken into account.
No.
Lordship, that is the thing.
You have placed your objection. Let me say the legal point, Lordship. My submission is that, Lordship, initially he was taken into 5 days remand. It is there in the police custody. It is there in the diary, Lordship. It is not my own submission. It's from the available. 5 days. Thereafter, 9 days. 9 days he was in custody. And after the 9 days, when he has sent to judicial custody, till date, nobody has arrived in the judicial, before the jail authority for the purpose of interrogation, Lordship. Because they are satisfied and the affair, pursuant to the affair, recovery has been made, Lordship. That's my respectful submission, Lordship. Pursuant to this affair, recovery has already been made, Lordship. And if anything further, if anybody has, they will definitely come up with an affair. Without affair, police cannot take show moto action, Lordship. There has to be an affair. And pursuant to that, only that can be acted, Lordship. Now, it's not that I have filed an application within 10 days or 7 days. It's been 40 days, nearly 2 months, Lordship. And he's also a patient. That record I have not brought into record, Lordship. He's having a hernial problem. So, Lordship, if you have any stringent condition, Lordship, he will cooperate. Rest of the, and those the recovery are already there. Jima are already there, Lordship.
I have already stated, Lordship, the initial conception, initial reception is there, Lordship. Because of that, he has done the sitting, Lordship, and the ingredients of criminal breach of trust is also there, Lordship. And moreover, regarding that FIR, it is already stated that during the course of investigation, it has transpired that more victims are involved in similar transactions, Lordship. In this connection, so and so, Lordship, other persons are also there. There is FIR also there. So he's not a person that he is a habitual offender. Lordship. I want to focus on that point. He is a habitual offender, and cheating of ingredients of initial deception is there, Lordship. From his mental condition is there. I am focusing on that point, Lordship. And criminal breach of trust is definitely there, Lordship. He has not returned it willfully, Lordship.
Hard MST so they learn it conflict for repetition. So Mr. KK, that's it. Additional PP appearing on the state response. This is an application with section students connection with students. CDDC to PDC. It is submitted by MS soon that the federal accused petitioner is innocent and he has not committed any such act as it is the end. However, it is a fact that he being he entered into an agreement with the victim and took two vehicles on rent, but as the other family the other family members were also involved. And no, took the vehicle on rent, but thereafter it was further rented to in Pasikat area by one of his family members. But during investigation, he helped the police in recovering those vehicles, and both the vehicles which were mentioned in the FIR has already been recovered, seized by police, and vehicles were already given to Jimma to the court. He further submitted that accused was in police remand initially for 5 days, and again it was extended for another 4 days. And after 9 days of police remand, the accused person was sent for judicial custody. But during his 9 days of custody, he cooperated the IO in the investigation of this case, and that is how the 2 vehicles were also recovered from the Pasikat area. The accused, at present, the accused is in custody for 38 days, and hence he may be released. He may be considering, and hence considering his length of detention also, he may be released. She further submitted that after the police demand, the police never interrogated the accused in the jail premises and for further cooperation in the investigation of this case. However, he is still ready and willing to extend his cooperation if he is released in bail, if he is granted the privilege of bail. Mr. Das Dilan additional PP submitted in this regard that though it is seen that as per FIR, it is seen that the vehicles were taken on rent by the present petitioner, but from the materials available in the case diary, it is seen that the present informant is not only a victim, but there are many more victims wherein the petitioner had committed similar kinds of offense, and his modus operandi is also same. In some of the cases, he even sold some vehicles outside the state and outside the state in the name of taking the vehicle on rent. The case is still under investigation, and the petitioner being the habitual offender, his further custodial interrogation is recorded for the interest of the purpose of investigation. Mr. Das further submitted that from the materials in the case diary, it is seen that the intention of deception is at the beginning while entered into an agreement, and thus there is clear and thus the case establishes under in cheating as well as in criminal breach of trust. Next paragraph. MS Song, the learned counsel for the petitioner, further submitted that the present FIR has been launched for 2 vehicles which has already been recovered, and if some other vehicles are also involved, the FIR might have been lost already in the other police station, but the present vehicles which has already been which are already been recovered by police during the investigation, and hence his further custodial interrogation may not be necessary for the interest of the investigation. I have recorded your submission. I'll pass you.
Learned friend says that is fixed on
Now he's
more law.
tomorrow he has
I have
personal-
some problem law.
Then it's
on my lord. Already matter is fixed on my lord on day after tomorrow, my lord, if possible.
day after tomorrow will be
It was fixed on 24th, no? 26th of March, lordship.
My lord,
He is
difficulty is
raising
that
the issue.
difficulty is that, my lord, in this case, my lord, one report was, yes, I have gone through the one earlier order is also there, my lord. So regarding now the question is, my lord, he dispute his identity. So if matter is, my lord, kept pending here, my lord, how his identity can be, my lord, revealed, my lord? Only the trial court can, my lord, otherwise search sheet submitted against the present accused person, name against Mofidul Mintaz Ahmed alias, my lord, Mofidul Islam Das, present petitioner, name is there, my lord. And now he,
No,
while
why
he,
he filed this petition, in fact,
uh,
whether any case has been registered.
yes, my lord, my lord, whether, my
So, I
no.
mean, misleading petition you have filed.
Now he
Kindly
stated
order,
that, my lord, in
there is judicial order 21/11/2025, lordship.
By this court.
Yes, lordship, 21/11/2025.
Where
he
did
is
it
declared, my lord, NBWA
Why it is, my
PNA
lord, report
issued,
was called for, lordship.
he was declared as proclaimed
In that
offender,
order, my lord, it is clearly, my lord, recorded, the report is necessary. IO has to submit report, lordship.
Then, my lord, he will have
Last
to
of
appear before the IO,
20
submit all his documents, my lord, Aadhaar card, and then only IO can, my lord, otherwise now summons issued by the trial court, my lord.
After this order, IO, my lord, visited my home lordship.
Collected the documents.
And collected documents, verification was done, lord. So what was the findings of, my lord, what was found by the IO lordship? That may be submitted before.
Here, what do you want now?
My lord,
From
today,
this court, what do you want now?
today, my lord, mention our, my lord, it was adjourned, lordship.
No. What from this court? What do you want by this?
My lord,
petition?
my lord,
Then, my lord,
initially, AB was filed, lordship. AB was filed, lordship, anticipatory bail application, lordship. Now,
On one hand, you are challenging your identity, and
yes,
the other
lord,
hand, you are
I am saying that,
taking
I am saying
for,
yes,
anticipatory.
I am saying that I am not that person, lordship, against.
Why don't you file a petition before the learned trial court below?
My lord,
If it is case is already charged, isn't it?
search case, lordship.
Then you can challenge your identity before.
But
the trial
IO is
court.
coming to my home, lordship. No summon, nothing, no NBW was, my lord, issued against me. But when then, my lord, IO is visiting.
yes,
So you are shown as an absconder then.
NBWA issued, my lord, PNA issued.
My lord, that is different person, lordship.
Different.
Proclaimed, my lord, fact is lordship.
No,
My lord,
yeah, I can understand. If you're not the person, then you're challenging your identity. You can very well appear before the learned trial court below, saying that I'm not the person.
then I may be protected, lordship. Otherwise, proclaimed offender.
Related 2060, let us see.
Yes.
Now I don't have time. Yes.
Yes, lordship.
Okay, good.
Yes.
Obliged, lordship.
Now, report to key report. What kind of report from police station?
Yes, my lord, report. Then I will have
You
to
are
again
saying
go
report.
through, my
What
lord,
kind of report is calling for the police station now?
report, my lord, regarding whether any, well, I will have to go through that order, my lord, on 26/3.
Obliged, lordship. Then number 19.
May it please, Your Honor.
Yes.
So this is a regular bail application manner. The petitioner has completed 632 days. The charge sheeted matter, my lord, NDPS commercial quantity is involved.
Oh, actually.
Yes.
See, now 632 days.
632 days, my lord. My lord will kindly see the FIR. FIR is at page number 16. As per the FIR, my lord, around 968 numbers of PES plus tablets were allegedly recovered from the possession of the present petitioner and one of the accused. My lord. Those two accused are named in the following page, at page number 17, Sachin Kumar and Firoz Ahmed. Thereafter, my lord, police submitted charge sheet under 222C 29 NDPS Act against the present petitioners and 3 others. Out of these 4 accused persons, my lord, 2 were granted bail by this honorable court. The bail order is at page number 36. Sir, my instruction says that till now, out of 6 PWs, 1 PW has been examined. It may be more. Two PWs have been examined. Both are Caesar witnesses.
No, one police person.
One police person, one Caesar witness. Now, my lord, my only contention in this case is regarding my lord, non-compliance of 4740. That was previously 50 CRPC and 50A CRPC. 50A CRPC, that is the notice to my lord the guardian. It was not never issued or never received because these are my lord old cases, my lord. 2024 arrest, my lord, was made on 16/6/2024, where my lord, perhaps the police officials were also not aware, very much aware about these things, my lord. Now, my lord, they are aware. But that time, my lord, and if your lordship will kindly see the 50 notice at page number 22. This is the 50 notice, my lord. A typical notice, my lord, no grounds mentioned. So at this stage, my lord, without going into the merit of the case, my lord, only on this issue regarding non-compliance of my lord, these 2 notices, my lord, lordship may kindly consider the bail claim. Because the other person, my lord, was granted bail on these issue itself, my lord. At page number 55/2025, the previous order, bail was granted to Yusuf and Monser, relying on my lord Probir Purkast and Vihan Kumar.
Yes, my lord. Out of 6 PWs, my lord, 2 were already examined, my lord. One is the Caesar witness, one is my the police personnel, my lord. Informant, my lord. Thereafter, my lord, his bail petition was filed before the court below, my lord. It was rejected on 8/1/2025, my lord. And regarding my lord, Lordship, before that, my lord, Lordship kindly page 21 of their petition, my lord. Forwarding report. My lord. In course of investigation, my lord, grounds of arrest thereafter, my lord. In course of investigation, deadline I have concealed, my lord, then the ground of arrest is intimated to them and his relatives by issuance of 50 and 50A CRPC notice, my lord. He has also been informed about his legal rights as per law. In the forwarding report, my lord, it was mentioned that 50 and 50A notice was issued to him, my lord, regarding the accused persons, my lord. I have gone through the record, my lord. The record, my lord, that 2 notices are not available.
2 notices means?
My lord, 50 and 50A notice, which was issued to the accused man, that is not available in the record.
But he has already submitted one.
One, my lord. He has
50,
submitted one, my
50
lord.
only submitted, 50A, I don't know.
Not.
Because our contention is that we did not receive that notice. So that's why it was not enacted.
No, but here in the ground of arrest, it was mentioned.
And my lord, these are certified copies. Probably in the record also it is not there. Probably.
এটা লিখে আছে তো, PMT
No. Wait, certificate
But in the record, my lord, none of the my lord, 50 and 50 and none, both are not available.
Even suppose 50A is may not be there, but in actual case record
Might.
may available. I
Might.
won't say. The question is that 50 is a certified copy they
Might.
have already furnished.
Might.
In 50 CRPC notice, grounds of mention has admittedly not mentioned. So at this stage, even if suppose 50A is not there, but we cannot expect that
My lord,
the
maybe
grounds
my
will
lord,
be met.
grounds of arrest maybe
But
or may not
obviously,
be
as
there.
per your submission, 50-50A CRPC was already furnished,
Might.
and he is also intimated his legal right
Might. Might.
that he can apply for bail or the
Might.
legal counsel can clear. That is already on.
Might.
Okay. And the rest of the cases that the some of the co-accused person most
Already
probably granted
done
bail on that.
But
that
from the present petitioner, it was recovered. He is the main my lord. He is from Bihar, my lord. He went to the Assam, my lord, and sold it, the contraband in different places in Puri.
from his position already.
Possession. It was recovered from his possession. And also my submission is 37 embargo of section 37 will come back here as my lord. It is in the commercial in nature, my lord.
Lordship may impose strict conditions, my lord, not to go beyond the jurisdiction of the lower court, my lord, if granted bail.
He is from Bihar, my lord. That is
But from the other two accused persons were earlier granted bail.
Nice.
One Yusuf and
Mild.
one Monsieur. From their position, it was not.
not recovered. Not. And from that is also there 47, 48 notice regarding it also of discussed. But from the
I'm
record,
just asking about the recovery. Recovery was
not recovery from. But here is the recovery from him.
But without submitting marks on merit, my lord, the seizure witness which was examined, SPW1, he completely negated the prosecution story. He said that, my lord, nothing was recovered in his presence. And police did not record my statement. It is the seizure list he exhibited. So Lordship may want to see that.
how many seizure list are seizure witness? As a whole?
One-
Is any other seizure?
Others are also there.
Yes.
Other,
Probably two are there, my lord.
2 and 3 never.
2 and 3. 3 is examined.
In the record also.
So he was declared as an hostile witness.
Hostile.
It's not completed.
Right.
I will see from here.
Right. And my lord, his date of arrest was my lord. Again, 15/6/2024. This is much before the my lord Mihir Shah, my lord, Mihir Ranjan Shah, my lord. That is the case where he
Not
was,
relying on Mihir Rajesh Shah, my lord.
my lord, here what he said here in the page para 58, my lord, it is henceforth. It was also mentioned.
Not relying
the-
on Mihir Rajesh Shah, my lord.
That is, I am relying on that.
Bobby
my lord.
Purkast is clear on this, man.
Lordship may also call for a report from the concerned my lord. Report, my lord,
Regarding what?
whether the 50 and 50 notice there in the record. Original record may be there, my lord. And it was whether it was served or not, that
Whether it was?
served or not, my lord. But here
You have not received, found any
not
anything.
my lord. 50 and 50 record.
No, obviously 50 was served on him.
My
It is there.
No.
Without mentioning the proper grounds of arrest. That is there.
My lord, that is
And 50A, I don't know, 50 you want to
my lord.
verify
That
it
is
or
not
what?
available in the record, but As per I have already said, my lord, in the forwarding, my lord, it was mentioned that if both of them.
But it's a matter of record, my lord, without going into the nuances of 50A, my lord. Even from 50 notice, my lord, it's clear, my lord. No grounds have been mentioned, neither, my lord, the grounds were communicated, my lord. But it's a matter of record, my lord. I've submitted a certified copy, my lord.
That's what I'm
My
saying.
lord.
Other than the time. Mr. S. Dilan, Mr. B. Sharma, Dilan, there's an application, the section scan copy, see, submitted by Mr. Das, the President, the Council for the petition, that the President's petitioner got arrested in connection with this case. He was arrested on which day?
16/6/2024.
16/6/2024. And as on today, he is in custody since last 600 days. Further submitted, it is alleged that some contraband was recovered from his possession, and accordingly, the case was registered and charged under Section 22C of the 29 PS Act. Till date, out of 6 numbers of witnesses, only two witnesses could be examined by the prosecution, including one Caesar witness. He further submitted that 2 co-accused persons were already granted bail by this court, considering the non-furnishing of ground of arrest through 50 and 50A CRPC notice corresponding to Section 47 and 48 PNSS. He further submitted that from the present accused petitioner also, there was no proper compliance of 47 and 48 PNSS corresponding to Section 50 and 50A CRPC. He submitted that the certified copy of the 50 notice, 50 CRPC notice has already been furnished along with the petition, where it is seen that there is no ground of arrest mentioned in the said petition except case number and case number, the date of arrest. At the same time, he submitted that the members of the present decision who hails from Bihar has not received any notice under Section 50A CRPC, which ought to have been furnished to the family members intimating his next. Mr. Das accordingly also relied on the case of Prohibitions and become very is when it is held that the grounds of communication of written grounds of arrest through 47 and 48 PNSS is mandatorily required, and otherwise it will amount in violation of fundamental rights of the arrestee granted under Article 22(1). Further, Mr. Das also submitted that considering the case of the present petitioner in the same footing, a prayer for bail may be considered for the petition, and he will extend his cooperation and he will appear regularly before the London Court below. And then when his and as and when they did next part. Mr. Das the learned petition will be submitted that the present accused petitioners are very much involved in the alleged offense, and from his position only the recovery was made. Recovery was made. He further submitted that till date 2 witnesses could be examined by the prosecution, and the case is still under investigation. If the accused petitioner is granted bail at this stage, there is the probability of absolute can be denied as he hails from the more so from the forwarding report itself it is seen that the petitioner was provided with the notices under section 50 and 50A CRPC, and his legal rights were also and intimated and so and thus his legal rights has also been informed to the petition. Mr. Das Sharma accordingly submitted there is sufficient compliance of section 50 and 50A CRPC and 50A CRPC. Accordingly, Mr. Sharma raised waiver objection and submitted that it is not of victims to extend bail to the present petitioner. What a submission before Mr. Das in an account of petition further submitted one of the Caesar witness whose evidence has already been recorded by the prosecution is not supported the case of case the prosecution and denied his presence at the time of the recovery of
Well, one more plea may be recorded regarding prolonged incarceration.
Mr. Das further submitted that considering the prolonged incarceration of the present petition, his prayer for bail may also be accepted. Okay, we'll go through the record and pass the order.
Right.
I have
Highly
recorded yours. Into numbers. Yes.
Second time, my lord, almost all the other accused already got released. And your lordship, yesterday also your lordship passed some order, my lord. I think city may be here, your lordship. This is a case, my lord. I think if your lordship can only go through, my lord, 44 days today, my lord. It was. You are something.
423.
This is the.
420.
Yesterday not listed.
420. 420. Not this one.
Earlier rejected by your lordship, my lord. Earlier rejection order is at phase 20.
Yes.
Today CD is not available. Phase 20 is the rejection.
Somebody, if CD is here, my lord, your lordship may, that is my, if
It
CD
is
is here.
already here.
Yesterday it was there in court number 23. Man. That is what I'm saying.
He is also one jewelry shop owner.
Yes. The owner, but seizes was some of the items, not all the items, my lord. In yellow kind is his seizure list, but page 39, last page, man.
Okay, then we'll try to. Can you make
Yes,
that
ma'am. I
inquiry?
will check my if in my office. If my CD is available, then at 2.
Yes.
But day after tomorrow, today,
Day after tomorrow.
day after tomorrow.
But day after tomorrow, can it be retained?
If my
Because
CD is
tomorrow
available,
already
then
list is there, so when one supplementary will come definitely, and 2, 3 will come otherwise. So may not be fixed, and day after tomorrow it can be fixed. But the condition that the CD should be retained there.
yes, yes, ma'am. I will
If you
check.
can give an information to your office,
Yes,
it
yes,
will be
yes.
retained.
I think it is that yesterday, my lord, since
Okay,
it
then yes, it may.
obliged to.
Okay, heard Mr. Inchai Chaudhary, the London Senior Advocate, assisted by Mr. M. Hussain, the London Council for the Petition. Also heard Mr. P. Ward, London Petition. Is submitted by Mr. Chaudhary that in connection with the same affair, one case was disposed of yesterday by court number 22. By this court, by the coordinate bench of this court, and accordingly he submitted that the same CD may be available in the office of the public. In view of this, let the matter be accordingly listed on 12 3 2023 the learned additional PP is hereby asked to make the irrevocable. Now, asked to call for the CD if it is available in the office of the public prosecutor.
Obliged.
70.
May I please, Your Lordship?
Yes, it was unrepresented, and I thought that Mr. Hawk was available in the
I'm
morning
sorry,
hour.
Lordship, I'm sorry.
So I
Lordship.
thought it
But-
should be timely.
Lordship, I'm sorry. And Lordship, we had this case, Lordship, the 67 days in custody, Lordship. As per the FIR, Lordship, some fake currency note has been recovered from 2 numbers of bag, Lordship, recovered from the GRPS Kamakya railway station, Lordship. And the petitioner was suspected and they were booked in this case, Lordship. But the petitioner strongly denied that their bag is not belonging to them. And Lordship, and as on today, Lordship, say 67 days in custody. So my limited prayer, Lordship, length of detention may be considered.
The total fake currency recovered from the present petitioners, my lord, value of the fake currency 33,000, my lord. An FSL report also received confirming that those are fake currencies, my lord, counterfeit currencies. And regarding the my lord, from the possession of the present petitioner, my lord, those fake currencies were recovered.
Part F of the learned counsel part is to be waterproof. The learned additional PP appearing on the offset response. It's an application. CD receipt. It is submitted by Mr. Hawk that the present accused petitioner is innocent, and nothing has been recovered from the position. The alleged recovery of fake currency and fake currency from 2 bags also does not belong to the present petition. However, the petitioner is in custody since last 67 days, and hence, considering his length of detention, his prayer for bail keeping the president of his address locality will appear before the IO as and when his cooperation will be required. Next, Mr. Watford Learned additional PP is objection and submitted that the fake currency of rupees 33,000 has been recovered from the position of the present accused petition, and from the FSL report also it is seen that those currencies were the counterfeit currency which were recovered from the position of the accordingly submitted that further custodial interpretation may be necessary for the purpose of investigation. During the submission made by learning officers in the case bank, and without going further detail into the merit of the case, that the further custodial interrogation may not be necessary for the interest of the investigation, as the IO got sufficient opportunity to interrogate, keeping him in the time. It is to extend the privilege of it. Okay, you will update.
Obliged. CGM Kamrup Metro Gauhati.
CGM Kamrup.
Metro Gauhati. Obliged, Lordship. Deeply.
23.
Yes.
Yes.
In
what
this
is
case,
the-
we were granted interim protection on 11/9/2025.
11/9.
23
Since
case
then,
diary,
my lord,
case diary not
case
received.
diary is not.
Why it is not received 11/9/2025 it was granted? Is there any intimation from the IO? Otherwise, as per your information, you have already
We have appeared, my lord. We have appeared. We have appeared in September, my lord.
We'll get the one my lord, last opportunity may be granted.
It will be last opportunity only because
Yes.
11/9 is
Yeah.
hard Mr. Nawaz to on account of the petition also hard. But we bought for the learned additional people paying on the offset. So it is submitted by Mr. Portable that he did not receive no intimation. that context, Mr. Nawaz, petitioner submitted that the present petitioner was granted with the privilege of pre-arrest bail on 11/9/2020. Accordingly, they also appeared before the is accordingly submitted that since 11/9/2025, the bail is pending before this court. In view of this, the IO is hereby directed to furnish the case diary on or before the next date of positively on for the next date of listing. In the form, he may be served with a personal show post office, and at the same time, the consequence of order be also passed. List the accordingly, which can be
Since the Lordship is giving a last chance, that Lordship may give a long date so that by positively it can come back. On my Lord, 6th of April.
6th of
6th. Interim may be extended.
yes, obviously.
Oh, deeply of as well.
Interim be extended till next.
25.
What is the position of 25? It was one disposed matter was there, I think.
Case diary received petitioners are in interim mail. I have.
Along with one disposed AB is there, no?
Yes, one disposed AB is also there.
Anyway, they were on interim.
Interim mail.
You have received the case.
Yes, case diary received a detailed report of the IO also received mail.
Detailed report of the IO.
IO and regarding there are sufficient material against the accused persons. My lord, in the name of initially, your lordship, my lord, earlier was pleased to grant interim protection to allow ultimate one Dhan Kumar Deka on the ground of some, my lord, due to some technicalities, my lord. And later on, my lord, these persons are also granted, my lord, interim protection, my lord. In the name of opening, in the name of running a, my lord, fake, my lord, railway union, they are involved in, my lord, and some allowing some of the, my lord, victimized persons to recruit as a member of that union, my lord, thereafter collecting huge money from, my lord, all those victimized persons in the name of providing job to the railway, my lord, department. By using also, my lord, there are lots of allegations of, my lord, using fake logo of the, my lord, railway, and also, my lord,
there are sufficient.
sufficient.
So initially, now how many petitions are here?
Here, 2 petitioners.
These 2 petitions are now presently.
Now, my lord, I have received a report, my lord, along with detailed bail objection from the IO, my lord.
No, but I'm just asking whether both the petitioners are on bail now?
Yes,
Now?
interim.
Then today we may not go the detail of the case.
Yes.
Can you retain the case diary which we were shorted because no one is appearing?
Yes.
And if it is in the case, if they are not appeared, then matter will be decided accordingly. One chance maybe.
Yeah.
And none appears on call for the petition. As Mr. Bboard, then it CDDC retain the case diary.
In fact, after obtaining interim also, my lord, they have not appeared
Okay.
before that.
And then when it can be listed? Don't give a very long date. 16 or 17?
Next, yes, 16 or 17. 16.
16? You're listing it on 16, that then on that day it may be disposed. Retain the case date till next date of listing. Interim be continued.
May I please your lordship? This is a pre-arrest bail application, lordship, and it's very long.
Here, case diary not received, my lord. Krishna is in interim.
You are on interim.
Interim, lordship.
CD not received, issue remain. When it can be listed?
My lord, on 3rd of April.
3rd of April?
Oh, 3rd of
No,
April.
3rd is holiday.
7th of April.
7th of
7th.
7th for interim be continued till next date of listing.
Published, lordship. Published.
Yes, 33.
May it please your lordship. Your lordship, senior counsel suddenly took ill and she had to leave the court. Your lordship, I humbly pray that the matter be listed for tomorrow or day after, your lordship.
Your senior is G. Bora.
Yes, ma'am. Yes, your lordship.
Otherwise, we have received the
My
case
lord,
idea.
case diary receipt.
You are MS?
Yes,
Your good name?
Reach.
Reach.
Yes.
RMS Reach. He was spelling to Silo. The learned counsel appearing for MSG Bora and submitted that due to sudden illness, the NPS counsel had to leave the court premises. And Mr. Sharma, the learned PP, submitted that CD has already been received. In view of this, whether they are on interim, no.
Interim, madam. They are interim.
And day after tomorrow, many
No.
matters are there, I think.
Friday, madam.
Friday, Friday,
Friday.
Friday, key तारीख? 13.
13th, madam.
Retain the case date till
Hmm.
date of listing, entry with the
13th.
list.
46.
Obliged, your lordship.
Yes, what about the 36?
36, my lord, I am appearing. Yes, my lord, kindly give me 2 minutes time. One of the petitioners has been arrested.
My lord, I have the information.
I say no, verification.
Samson.
And there was 2 petitioners were there.
No, my lord, there are 6 petitioners.
6 petition.
Oh, six
Petitioners number 4, 5, and 6 are on interim.
4, 5, 6.
Are on interim, my lord, and they have appeared. 1, 2, and 3 were not granted interim, out of which
Samsul Haq was arrested on
number
4-3.
2 has been arrested. So against for him, my lord, it will become
2 arrested.
2
Yes,
arrested.
And 3, who are the interim otherwise?
4, 5, and 6 are on interim, my lord.
4, 5, and 6.
6 you are interim.
So 1, 2, and 3 was not there, and 2 you are not.
2 is
taking
already
the
arrested.
action,
1, 2,
already-
1 and
already
3 is there.
1 and 3 is there.
1 and
One
3.
and-
Here, your lordship will find the FIR at page 12. This was a case of a mutual market which took place between 2 groups, my lord.
Hmm.
Page 12, my lord. May I read the FIR, my lord?
Yes.
Sir, with due respect, I beg to inform you that on 23/1/2026, at around 8:30 a.m., the above named accused persons armed with sharp weapons, sticks, and rod trespassed into the premises of my home, hurled obscene abuses, and tore the boundary net. When my elderly father and I tried to stop them, accused number 1, 2, and 3, with the intention of killing my elderly father, attacked him on his head with a rod and cracked his skull. Having lost blood from his head, my father fell down. They also broke my father's left thumb. The accused number 2 attacked me with a bamboo stick and seriously injured me. On the instigation of accused number 6, the other accused persons pushed my mother to the ground, attacked her with sticks, and tore her clothes. The accused persons did not stop there and attacked my father with sharp weapons and caused serious injuries to him. When we raised a hue and cry and the neighbors arrived at the scene, the accused persons threatened to kill us and left. We took our father to Kanpur FRU for treatment, but he was referred to Nagaon Medical College. After 2 days of being treated at Nagaon Medical College, when my father's health condition deteriorated, the doctors of Nagaon Medical College referred him to Gauhati for better treatment. And now my father is admitted to Gauhati Aruna Memorial Hospital in a critical condition. As I was preoccupied with my father's treatment, there was a delay in lodging the FIR. So as per the FIR, the attack was perpetrated by 1, 2, and 3. But they have also said one thing, that it was done at the instigation of the accused number 6. Now, your lordship will kindly come to page 21. Page 21, this is the identity card of the accused number 6, my lord. He is an engineer working with NSIDCL. Page 24 is the attendance register of that relevant date, showing that he was on duty on that day. And page 24, my lord, is a photograph with a timestamp and date. Page 24, if your lordship will see. Same date on 23/1/2026. So he is on duty in a place which is more than 30 kilometers away, my lord. In Zokhalabandha area, my lord, he is working there as an engineer on site. This timestamp photo is showing. So they are trying to project that this petitioner number 6 was also present there at the time of occurrence. This falsehood is very manifest, my lord, from the face of it. 4 and 5, there is no specific allegation against 4 and 5, and these two were the neighbors, my lord, who had gone to the place of occurrence when this incident happened. And there was a land dispute ongoing between the informant's family and this petitioners number 1, 2, and 3, and that part we are not denying, that on that day, there was a fight which took place between these two parties, my lord, between the accused petitioners number 1, 2, and 3, and the informant's family member, in which both parties sustained injury. That part we are not disputing and not denying.
As regards 4, 5, and 6, since they have already appeared and cooperated with the investigation, my lord, perhaps your lordship can make it absolute. Regard 2, my lord, it is no longer there. 1 and 3, my lord, because of the existing land dispute and because of the fact that this was a case where there was a land dispute and there's a fight between them. Perhaps this is a case where custodial detention may not be necessary. Trial can, whatever has happened, who was the real aggressor and who were the victims, all of these things can come out in the trial. Person has already been admitted, he has been treated, and he has gone home. So perhaps detention may not be necessary. Subject to what
My lord, here, lordship, some eyewitnesses also there, my lord, in that case there, my lord. Regarding the video, my lord, petitioner number 6, my lord, Badruddin, my lord, he is Badruddin as well, my lord. All said that, my lord, he is the engineer of the, my lord, that at that time he was in duty, my lord. From the photographs, it reveals that lordship kindly page 24, my lord, there between time 23/1/2026, 9:40.
Yes.
Page 24.
Yes, what time?
Time, my lord, in the column, my lord. Time 23/1/26, 9:43. 9:43. In the photograph. And the incident occurred at 7:30 to 8.
8:30, my lord.
7:30 to 8. And he was very much present at that time from the eyewitness. And regarding the medical injury report of the my lord Liaquat Ali, my lord, injured person, my lord, his injury is grievous by blunt object. Laceration on skull 5 × 5 cm and type 2 compound fracture base of first metastone with fracture. My lord, one fracture is there also, my lord. Left hand. Scalp and left hand, my lord. And CT scan was done, my lord. It was done, my lord. CT scan also done, my lord. And from the other statement and witnesses, eyewitnesses, my lord, let me kindly place one eyewitness, my lord.
We just make 2 submissions subject to what is there in the statement, my lord. First of all, my lord, what my learned friend has said, FIR itself is very clear. If your lordship sees the FIR, it is at 8:30 a.m. My photo says at 9:43 a.m. Incident, your lordship will know the topography of that area. Incident took place in Kanpur. And I am there in Koliabor bypass, my lord. From Kanpur, one has to first come to Nagaon. Then the person has to go to Koliabor. So at 9:33, I was part of this big attack on this person. And then from 8:30, I could come to Nagaon. Then go to Koliabor. Then click a photo, all within the span of 1 hour, my lord. That itself shows the improbability. And your lordship, in the medical report which my learned friend has read out, that itself makes my case, my lord. If it is grievous injury caused by blunt object, then it's a bailable offense.
But in the vital part of the body, my lord,
Irrespective
it
of
is
that.
the my lord, scalp, my lord. That CT scan was also done. My lord. He was in several
This is also recorded under 109 or what?
109.
109 is
109.
109 is there.
109 is there. So, my lord, the classification of the offenses is not based on where the injury is caused, rather by the means of the weapon by which the injury is caused, my lord. So, if it is caused by blunt object, irrespective of where it happens, that is why it is grievous, and that is why the punishment is 7 years. So, in trial, he will go and face that. If he is convicted, he will be punished for 7 years. But the legislature, in all its wisdom, has made offenses where the attack weapon of attack is not a sharp weapon or an instrument of cutting. Then legislature has made it a bailable offense, man. That is the wisdom of the legislature. We cannot second guess that.
Section 109 clear, my lord. Even if my lord is in the vital part of the body, my lord, whether it is blunt object or sharp weapon, that is not the matter, my lord. If it is in the my lord vital part, he may die also. In one stick blow, he may also die, man. That is there, man. But if it is not necessary that it is sharp weapon or that other instrument, it is not there, man.
The injury says it's a fracture, my lord. Nobody dies from a fracture, my lord.
But one injury.
The other is a laceration weapon, laceration wound.
5 cm into 5.
It's a laceration, my lord. So nobody dies from a fracture and a laceration, my lord. So this is stretching things too far, my lord. And we have said that we have not denied the fact that this 1, 2, and 3 and the victim and the informant's family had a fight. That was over a land dispute. And the falsehood is quite apparent that the way they have falsely implicated 6, who was not present at the scene.
And from the
That-
witnesses, it also reveals that he is the engineer.
Yes.
For that purpose, my lord, he instigated the others person, my lord, as he is the, my lord, all of them follow him. My lord. That part is also there. My lord.
So, engineer.
That is okay, I have
Right.
seen. Otherwise, these 4, 5, and 6, they cooperated.
They appear, statement record.
And against who has already been
Arrested, my lord.
Who is one? One is
One
named
Harun Rashid
Harun
and
Rashid.
Nawaz Sharif.
Nawaz Sharif.
Harun Rashid and Nawab Sharif.
My allegations are there again.
Allegations are there.
Sir, we'll cooperate with the trial. If we are found guilty, my lord, we'll be convicted, my lord. Every attack does not necessarily, my lord, become attempt to murder, my lord.
Even if it is in the vital part, my lord, then he may die, my lord.
He did not die.
And regarding the Badruddin, my lord, that is CDR also there. In the objection is regarding his CDR analysis also there.
Badruddin number 6.
Number 6. CDR analysis of
So it's city receipt pages. It's never okay. Submitted was an accused petition. Number 2 has already arrested by police during investigation. Is by police is not going to press the petition for the petition number. We further submitted that accused petition number 4, 5, and 6 were granted, which the interim protection has already appeared before the cooperated in the investigation. And the statements were also recorded. Mr. Nawaz further submitted that though, as per the election in the FIR, the entire incident happened as per instruction of the accused petition number 6, he was not present at the relevant time of incident at the place of occurrence and being an engineer, he was busy with his project. And on the day of the incident, and into that regard, he has already furnished some attendance certificate as well as one photograph showing that he was busy in his work and about busy in his work. But only with some false and concocted allegation. The case is also lodged against the present petitioner number 6. However, it is admitted by Mr. Once that there was a quarrel in mutual market took place between two groups for being land dispute wedding. Both the parties sustained injury. Mr. Further, Mr. Nawaz further submitted that that all the petitioners are still ready and willing to extend their cooperation if they are granted with the privilege of the estimate. Next part, Mr. Sharma, the learned additional PP submitted that there are sufficient incriminating materials against all the petitioners who are involved in the alleged offense. If further submitted to the plea of absence is taken for the respondent number petition number 6, but from the available materials on record and the statement made by the witness, it is seen that the petition number 6 was very much present at the time of incident. He further submitted that the photograph which has been annexed along with the petition was clicked at about 9:43 a.m. on 21/01/26, and the incident had happened on 21/01/26 at about 7:30 to 8 a.m. Mr. Nawaz submitted in this context that that the incident took place. Where in incident took place?
8:30 a.m. is there in the FIR, my lord.
Incident took place in which
At
place?
Kanpur, my lord.
Incident took place at Kanpur. And the petitioner was working in which place? No?
My lord, Koliabor bypass, my lord.
Koliabor bypass, and hence within 1 year, 1 hour, it is quite improbable to a person to come attend his work after committing the crime at about 8:30 p.m. 8:30 a.m. However, he submitted that all the petitioners are ready and willing to extend their petition. Expert hearing the submission made by learning counsel of both sides and have also paid the case diary.
Regarding medical report.
No, sorry. Sharma out of petition department. Mr. Sharma department. Mr. Sharma, the learned petition PP further submitted that from the injury report, it is seen that the victim sustained, the victim, that is the father of the informant, sustained grievous injury on his person, and he also sustained one fracture injury on his left hand. And the assault was subjected to a blunt object. Mr. Nawaz submitted in this conflict that if it is a injury sustained by a blunt object, then it will be a case for grievous injury to a blunt object, and it may be considered as a bail offense. Next paragraph again, hearing the submissions. We see that the petitioner number 4, 5, and 6 were extending their cooperation and appeared before the IO during the investigation after obtaining the order of rearrest. However, it is the fact that during investigation, the petitioner number 2 has already been arrested. Likewise, coming to the involvement of the accused petitioner, it is seen that there is the accused petitioner number 1 and 3 is very much involved in assaulting the victim. But from the record, it seemed that there was a quarrel between the parties due to land dispute, which turned into, which had ultimately caused the said incident. Considering this aspect of the matter, the circumstances under which the incident took place, and other relevant factors in the case, I find that custodial interrogation may not be required. May not be required at this stage. And in view of this, all the accused petitioners, none of the the interim granted to the accused petition number 4, 5, and 6 is hereby made absolute, and the petition number 1 and 3 also granted with the privilege of various.
I'm deeply obliged. Five, my lord.
Because we took the item, both the items together, because item number 5 and 9 are most well out of same FIR. And your matter was in motion column, but as the case is already there, so I thought they. Okay.
My lord, as per order dated 5, I have appeared before the investigation agency. My statement has been recorded, my lord.
As per order dated
5, my lord. Last order, my lord. Some interim protection was provided to me, my lord. As such, I appeared before the IO. My statement has been recorded. I appeared before the IO on 6/3, my lord, 6 months. On the next day, I have appeared before the IO investigation. My lord, FIR is at page number 13.
Now here, Waterford, if I remember one cases, there were some transactions
Yes.
where they are, bank officials are involved most probably.
Yes,
Regarding the giving.
in the name of my lord, excess borrowers, my lord. Total
Yes, fictitious
30.
borrowers.
Yes.
So in that case, one field officer was disseminated
Yes.
39, item number 39.
39 is the my lord branch manager.
Field
Field officer is item number 5, man.
I am the branch manager. Item number.
Oh, yes, item number 5 is the branch manager.
He is the branch manager.
My lord.
And item number 39 is the field officer.
Field officer.
Field officer.
My learned senior is in.
He can vote. Yes, Mr. Kaur, in
My lord,
39
in
you are.
terms of the interim order of this honorable court, I appeared before the investigating officer and recorded the statement. The investigating officer showed me the transaction details and all. My lord, all these transactions which have been referred in the FIR is not relating to my period that has been verified by the investigating officer, and I have recorded my the statement also. And so far, the your lordship's order or earlier order reflects that departmental proceeding was initiated against me. I had faced allegation during that time, and punishment was also imposed on me. And I'm still working at Nagaon after in a reduced level. They have reduced my rank. So far, the present FIR is concerned, the investigating officer thought that it was relating to my pay, and from the departmental proceeding which I have annexed in my petition, if the numbers are reflected, he compared and found that this present transaction does not relate to my period, madam. And I have cooperated with the investigation. I'm willing to cooperate with the investigation. Being a mother of children and being employed in a place outside now where the FIR has been registered in a different police station, that is at Polasbari, and I am posted in Nagaon. So I have no access to those documents and anything in relation to those accounts which are reflected in the FIR. That's my humble submission before this honorable court, that my custodial detention may not be necessary so far the investigation of the case is concerned, and I will cooperate with the investigation as and when required or as directed by the investigating officer. That's my humble submission for your lord.
And regarding the in that period, the petitioner is not in, my lord, as posted as branch manager in the that major branch, my lord. Regarding that, my lord, there is no.
She is most probably still a field manager.
Yes,
Yeah.
a field officer, my lord. Yes, but at that point, but her statement is available. From her statement, it reflects that at that point of time, she was posted as field officer in that branch, my lord. And for which, my lord, in the departmental inquiry, my lord, she was demoted. And my lord, and regarding the present case, my lord, there is in the being a field officer, my lord, she is entrusted to verify all those documents, my lord, which were, my lord, collected from the borrowers, my lord. But in fact, those documents are, my lord, some of the documents there, without verifying any of those documents, some of the, in the name of some fictitious borrowers, those are manipulated documents, and they are, my lord, ultimately on the basis of those, my lord, documents, but after verifying the field officer has submitted his statement is her statement is also available in the CD, my lord. Ultimately, my lord,
One thing, just tell me.
Yes, my lord.
Mr. Kaur is submitting that during her tenure or her period.
But regarding that, there is no specific note of the IO in the CD, but her statement is available. They appeared, both appeared statement recorded, but from her statement, otherwise during departmental inquiry also, suppose if she was not posted at that point of time, why she was promoted by the during departmental inquiry? But this is, my lord, a criminal case regarding these are economic offense. They are involved in misappropriating, my lord, public fund, my lord.
The incident took place in which year?
Financial year 2023.
And the account number, my lord, which are loan account number, which are reflected at page 20 and the 25 is different. That's why we went and cooperated. We showed the IO say, for this offense, I have already been charge sheeted by the department. I've faced the proceedings, demoted, now posted at Nagaon.
That means you were there.
No, my lord, this loan account doesn't involve me, my lord, at page 20 in the FIR.
Regarding those, my lord, investigation is still going on.
These loan accounts which are referred in the FIR is not relating to my relating to me. My loan accounts are at page 25, my lord.
The FIR is lodged by the, my lord, present branch manager SBI, my lord, and they specifically named the present accused persons. And at that point of time, from that FIR, my lord, itself reflects the name of a list of detailed name of the borrowers, my lord. And regarding, my lord, what
No,
about?
I will not argue on the merit, the
Yes.
problem, but
Yes.
the, so far the investigating
And
authorities.
regarding the talk between, my lord, informant and the IO, my lord, regarding those.
Okay, I'll go by what my statement is recorded by the investigating officer. My only humble submission that being a woman and now posted in a different place, custodial detention may not be necessary so far the investigation of the case is concerned, because the whole case is based on documentary evidence only.
She is saying that departmental inquiry was initiated against her due to certain other loan accounts.
Yes.
But present loan accounts, as per her, she is not really.
Yes.
And these in certain other accounts, those irregularities were found, and she was placed under
Yes.
suspension and now demoted also.
Yes. My lord, although, my lord, those things will be, my lord, looked into by the IO, well, because now in investigation at the initial stage,
Yes.
because otherwise specific allegation in the FIR is there, and for which she was also demoted, and the list of those loan accounts. Suppose she is not
So she
involved
was
in.
demoted for the not for the FIR, but for the other
Yes.
earlier her departmental.
Departmental action. Now also, my lord, this FIR is lost by the so maybe, my lord, in these accounts also she is involved.
Yes.
No.
Regarding those aspects will come on.
Well,
come
this
later
loan
on.
account number, specific instruction at page 20, I am not involved in. But whatever be it, my lord, I have cooperated with the investigation. I am willing to cooperate with the investigation. It's all about the documents which are in the custody of the SBI Bank of Polasbari, under Polasbari Police Station, Mirjabans. So I have no access to the documents. I have no access to any of the officers who are there in that branch at this moment. So my custodial detention will not be necessary. That's the only prayer your lordship will consider at this moment. And so far the investigation is concerned, your lordship will direct me to appear as and when required by the investigating officer. At least we are obliged to this honorable court that we can go and check with the record that whether because initially when this FIR was lost, I came before this honorable court. Now at least we have an opportunity to verify whether this loan account number reflected at page 20 and the 25 for which I have been charge sheeted by the department. Those are completely different. And I have specifically said that these loan accounts are not within my tenure. The IO has to now verify from the documents that whether this loan account number is anyway I am related. For that, we are willing to cooperate with the investigation. That's my humble submission.
Yes, Mr. Pam.
My lord, now I am working at SBI Gauhati branch. I have been demoted, my lord. Branch manager to deputy manager, my lord. Now I am working at SBI Gauhati branch. My lord, as per order date 5-3, my lord, I have appeared before the investigation agency. My statement has been recorded, my lord. So far as the FIR is concerned, my lord, there is no specific allegation against me, my lord. The specific allegation is against the, my lord, field officer and the branch service manager, my lord. My lord, so far as page number 19, my lord, I am reading the first paragraph, my lord. It is further informed that the concerned official appraised personal loan to the persons who were having history of written of settlement overdue amount in their CIC report as on the date of sanction. All these loans were done by violating bank extent guidelines. The concerned official appraised personal loan to the persons without credit to salary in SBI account of the borrowers. The net monthly income mentioned in appraisal were not credited in SBI account of the borrowers. Hence, the officials did not appraise the loan proposals with the required due diligence. Moreover, the appraised personal loans to persons who were not eligible for the proposed limit as per EMI, NMI ratio, existing obligations were not considered while calculating the eligible loan amount. The officials appraised personal loan without the necessary pre-sanction surveys which were required because of conversation of category of SB account of the borrowers. Personal loans are sanctioned By, my lord, this line is important, my lord. Personal loans were sanctioned by Mrs. Juridas Kaur while permanent branch manager was present in the branch. Similarly, personal loans were applied by Mr. Mofidul Hussain being a service manager, while a field officer was already present in the branch for the same, my lord. So there is no specific allegation against me, my lord. I have appeared before the investigation agency, my lord. My statement has been recorded, my lord. So I did not play any active role, my lord, at the time of sanctioning the loan. Yes, because the service manager, Mofidul Hussain, verified all those documents, my lord, and forwarded to the branch, my lord. So I did play any no role, my lord. So, my lord, at any condition, my lord, for the remaining, my lord, investigation, I will cooperate with the investigation agency, my lord. At any condition, my lord.
From her statement, it reflects that ultimately he is the person who ultimately verified those documents.
No. I am the branch manager. I am
yes.
not the service manager.
Yes, branch manager. Yes, your lordship may kindly see. He is the branch manager, my lord. 2024 পৰা 2025 সাসপেন্ড হৈ থাকো এতিয়া SBI ফালৰ পৰা দিয়া 1034টা পাৰ্সোনেল লোন জুৰিদাস কোঁৱৰ আৰু মফিদুল হুছেইনে ভেৰিফাই কৰি দিয়াৰ পিছত মই এপ্ৰুভ কৰিছিলো so he is the person who ultimately
মই এপ্ৰুভ কৰিছো on the basis of
manager, it is his duty, my lord, to verify those documents, not only because my lord field officer and my lord
Service manager.
Submission officer has submitted those documents before him. He is being the ultimate authority. It is his duty to verify all those genuineness of all those documents, identity proof. In fact, my lord, those borrowers who were not even government employees, but they have produced salary slip and all other IDs and other documents. Why without verifying those documents? Only because field officer and sanctioning another person, Mufidul Islam, submitted before him all those documents and ultimately he approved all those loans. Ultimately, branch manager is the approving authority of the loan.
No, my lord. I have not verified any documents, my lord. So far as my statement, I am not denying, my lord. I was the branch manager, my lord.
They are only
Field manager and branch service manager, all those documents verified by field officer and service manager. Then I approved them. I am not denying, my lord. But whether I have verified those documents, my lord, I did not
without
verify those
looking into
documents.
any of these documents. Only his duty is to make signature, my lord. That how that can be, my lord. All these documents are submitted before you, then I will make signature and everything will be approved.
That's why, my lord, field officer and service manager appointed by the SBI, my lord. If every manager has to verify all these documents, then the bank will not function, my lord. That's why field manager and service manager is appointed, my lord.
Branch
Their
manager
duty
also
is to
appointed
verify
by
those
the
documents, my lord. I am not denying, my lord. I will cooperate with the investigation
They
agency, my
appear
lord, at any
cooperative with
condition.
the
my lord, I will
investigation.
cooperate.
Otherwise, my lord, investigation is still going on regarding all those, my lord. And regarding
were
other
already
submission,
collected by the some of the documents.
some of the documents, pen drive, my lord, IO has, the bank has submitted along with the pen drive, all those documents. So regarding the verification of all those documents, regarding that aspect, no notice there, my lord, that is going on, my lord. Investigation is still going on.
But the loan accounts or the loan papers which were
Everything was, my lord, submitted with a pen drive by the bank officials, my lord, to the IO. Regarding that aspect, one notice there. One black and red color Scandix pen drive, 32 GB, containing KYC details, employment ID, pay slip, loan account details of 34 numbers borrower mentioned in the FIR of above reference case, staff details of Juridas Kaur, Mofidul Islam, Minal Das, present petitioner, mentioned in the FIR of above reference. So those Caesar list is regarding that. So verification regarding those aspects is going.
still going.
I will add only one small point. I have taken the instruction from a junior. This loan account numbers in the FIR relates to Mofidul Islam, who was acting not only as a supervisor, but of a field officer for this loan account. That's why this loan account does not tally with my loan account in the charge sheet. The loan account which are in the FIR is that Mofidul Islam, that gentleman was acting also as a field officer. That's why your lordship will not find these loan account numbers in my charge sheet.
Mr. Biggie funded and it's assisted by Mr.
P. Dole. P. Dole.
P. Dule, the learned counsel for the petition. Also had Mr. P. Botakur, the learned additional PP appearing. It's an application, it's connection with city receipt. It is submitted by Mr. Bond that after obtaining the order of interim pre-arrest bail, the petitioner has already appeared before the I cooperated in the investigation, and our statement is also recorded by the during the investigation and during her cooperation. It has come out that the loan accounts which has been mentioned in the FIR is not related with the bank accounts under which she was charge stated in her departmental proceeding. It is further stated that during her tenure, these loan accounts were not verified. Loan applications were not verified by her, and from the reliable sources, it is learned that one of the co-accused, Mufidul Islam, who was working as a service manager, had also verified the loan applications as working as a field officer. However, for some other loan applications, the present petitioner had faced a departmental proceeding, and she is already demoted under the said departmental proceeding as a possible post. But in the case of the present FIR, the loan accounts which were mentioned in the FIR is not related with her, and during that relevant period of time, she was not working as a field officer in the same branch. She further submitted that at presently she is working in a branch office at Nagaon, and hence there is no access to to any documents which are pending before the branch. Which branch cases of which branch?
Major branch.
Major. If Mr. Record, she submitted that the present petitioner is not connected in the list, and hence considering this aspect of the case, and her bail application may be considered. However, she is ready and willing to extend her cooperation in the further investigation of this case if she is provided with some interim. She is provided with the privilege of re-arrest bail. Next para, Mr. Bortaku, the learned edition PP, submitted in his report that after obtaining the order of interim pre-arrest bail, petitioner appeared, and her statement is also recorded by the. But from the available materials in the case record, it is seen that it is her who verified some of the loan accounts for some fictitious persons, and the investigation is still under process in verifying those documents which were furnished at the time of the loan applications. So she stated that she was not present at the relevant time of the incident in the said branch, but her name is specifically reflected in the FIR, as she is very much involved in the alleged offense and also involved in verifying those documents which were submitted along with the loan application by some fictitious person. So, however, it is submitted by Mr. Bortaku that all the documents were already collected by the investigating officer during investigation, and the verification process is still going. Mr. Bortaku accordingly submitted that raised objection and submitted that it may not be a fit case to extend the privilege of pre-arrest bail to the present petition. Next part, hearing this submission made by land counsel for both sides, I have also paid the case record in the matters in the case record in the case tag. There's a fact that the present petitioner is cooperating in the investigation, but the investigation is still under process as to whether all the loan accounts, loan applications were verified the present petitioner or not, and there is no there is no note on the I that during the relevant period of time, the present petitioner was not in the branch, and the documents were also not verified by her. But it is seen from the case diary that most of the documents had already been seized by police during the investigation, which were supplied along with the loan applications. Same time, it is also seen that same time it is also seen that the loan account number which has been mentioned in the FIR and the accounts number under which the departmental proceeding was initiated does not tally with each other, and thus it cannot be stated that she faced with the departmental proceeding for anomalies of the irregularities in connections with the loan accounts which has been mentioned in the considering all the aspects of the case, and also considering the fact that the IO has already collected the most of the documents during the investigation, I find that custodial interrogation may not be necessary at present, as the entire case is based on documentary evidence. The bail, the order of interim pre-arrest bail. This court is of opinion that order of interim pre-arrest bail granted to the petitioner dated record. Moreover, dated 11/2/2026 is hereby made absolute with same terms and conditions, with a further direction to the petitioner to appear before the IO within 10 days from the date of order and extend her cooperation in the investigation process. Next one, you.
We are deeply obliged.
Item number 5, heard Mr. Paramanik, the learned counsel for the petitioner, and A. Paramanik, the learned counsel for the petition, and also heard Mr. Sib Takiba. Under same connection, Takiba city received them. Next, it is submitted by Mr. Paramanik that after obtaining the order of interim pre-arrest bail dated 5/3/2026, he already appeared before the IO and cooperated in the investigation of this case. His statement is also recorded by the IO. Mr. Paramanik further submitted that being the branch manager, his duty is not to verify the documents, and those were supposed to be verified by the field officer as well as the service manager. For the said duty only, these persons are entrusted by the bank. Further, he submitted that for a branch manager, it is not at all possible to verify all the documents in detail and before approving the documents, and on considering the verification report submitted by the field officer and the service manager, the branch manager used to grant public sanction, approve the loan. He further submitted that he faced some departmental proceeding in that regard, wherein he presently demoted to deputy manager, and all the documents of the loan sanction application, etc., are not in his custody, and those were already seized by police during investigation. He further submitted during the entire the relevant period of time, the co-accused Mufidul Islam, being the service manager, had verified all the documents. On the basis of that verification report, the approval was granted by the petitioner being a branch manager. Mr. Paramanik further submitted that there is no specific allegations brought against the present petition in the FIR, and it is the field officer and the service manager who reportedly verified the loan applications and the documents. However, the branch manager is still ready and willing to extend his cooperation in further investigation of this case if he is granted with the privilege of pre-arrest bail. Stop next paragraph. Mr. Sharma, the learned, Waterford, the learned edition 50 submitted an mistake that he is the person who approved all the loan or in the name of some fictitious persons, which are not even a salaried person, though some salary certificate and the payslip and other documents were submitted before the branch. Being the branch manager, his duty is to verify the documents before any approval, and it cannot be said that only on the basis of the verification note the branch manager will approve the documents, approve the loan. More so, he already faced the departmental inquiry and demoted to deputy manager in the same branch. So Mr. Waterford however submitted that most of the documents were already seized by IO during investigation, and the documents are still under verification as the case is at a very initial stage of investigation. Mr. Waterford further submitted that though the branch manager had appeared and cooperated in investigation, his custodial interrogation may be necessary to unearth some more facts involved in this case. Mr. Waterford accordingly raised objection, submitted that it may not be a case to extend the privilege of pre-arrest bail to the present. Next, hearing the submission made by non-counsel consequences. Okay, the materials from the materials available in the case diary, it is seen that he, being the branch manager, used to approve the loan in the name of some fictitious person, but at the same time it cannot also be denied that verification report were submitted by field officer and the service manager, for which they were appointed in the same branch. But being a branch manager, before approving the loan, it is his duty to verify the report submitted by the service manager, the field officer. But without doing so, the loans were sanctioned in the name of some fictitious person. However, it is seen that after obtaining the order of the arrest bail, the petitioner appeared before the IO, and at the same time it is also seen most of the documents were already seized by police during investigation. The entire case is basically based on the documentary evidence. However, the further interrogation of the present accused petitioner also cannot be denied at this stage. In view of this, a interim protection granted to the present petitioner by order dated 2026 is hereby made with the following terms and conditions. And in the same time, the being a branch manager, being the branch manager at the relevant time of incident, he is hereby asked to appear before the IO after 10 days from the date of order, and to extend his cooperation as and when it will be required. Okay, condition.
Highly.
Forty, my lord, one report was called for from the, my lord, Nunmati police station. Report, my lord, not yet received.
Report was called for.
Your lordship will fix it on 13th, my lord, Friday, I can get it.
Report as called for is not yet received. The delayed additional PP will do the needful in calling the report from the concerned police station. List the matter accordingly on 13/3. 36. 40. We're listing it out. আচ্ছা, just a second, একটু কি করে একটু ডাটাটা আইটেম আছে বলে। আমি এইটুকু এনে খেলতাম তো খানা কেসটো শেষ হবরে কে কে খাতা করে দৌড়িব নোৱাৰো ফিক্স টাইম দিয়ক 3 বজাত দিয়ক মানে বেষ্ট টাইম আছে 10:30 বা 2টা বা 10:30 তেতিয়া কি হয় সেইটো পেজ কৰি বাকি ল'ব পাৰোঁ সেইটো আধাতে কিছু এনেকে কৰিব কিমান ল'ব
May I please your
you are
lordship?
for which you are for the petitioner?
Yes, madam. I'm the husband of the respondent.
No, whatever. You are for the petitioner?
Yes, madam.
And Mr. UK Goswami, it was appearing for the respondent. It's a matrimonial case.
Yes,
So state is a formal party here.
Yes,
Yes.
that is.
So whether Mr. Goswami is there or not?
In the first of he was there.
First of he was here.
I saw him in the park. Hello, what happened, my lord? The respondent, who is the wife of the petitioner, approached before the learned trial court.
Last occasion, it is ordered
Yes.
that in his absence, it will be heard. Because most probably on the earlier occasion, also earlier 2 occasions, the respondent was not represented. But I must tell you one thing before starting your hearing, that I have a matter with the division bench, with Chief Justice. So you start hearing, but it was informed us that at 2 there is a matter, and after the matter, the next DV may be there. So I'm going to hear the matter because it's not there, but in a halfway it may be closed. I don't know.
Yes, my lord, my hearing will be brief.
Just accommodate with this.
Yes, madam. And both the petitioner and respondent are husband and wife, and out of their conjugal life, their son was born. Kindly peruse the birth certificate of this son, Annexure A, page 12, my lord. And due to mental, son's name is Dipankar. And due to mental difference, my lord, respondent left her matrimonial house.
You are the husband, na?
Yes, I'm the husband.
And who is another?
Respondent is the wife of petitioner. And due to mental difference, my lord, the respondent left her matrimonial house. And although the petitioner tried his best to bring her back, but he failed to bring her back to her matrimonial house, for which he was compelled to approach before the learned Principal Judge Family Court by filing a petition under Section 9. And immediately after issuing the notice of that petition to the respondent preferred a petition under Section 125, praying for maintenance as well as some relief. Well, in the petition filed by the respondent, she stated
So this
that
order was passed by Principal Judge Family Court number 2.
Yes, madam.
You were directed to pay maintenance of rupees 7,000. So
7,000.
against that order you have come.
Yes, madam. Actually, the petitioner
submitted his salary slip during pendency of the case on affidavit. And at the time of hearing of that interim maintenance, the learned court below did not rely upon that document, only relied upon the false statement made by the respondent. Whereas, my lord, the salary of the petitioner is 19,000, like that is available in TCR. It is marked as flag mark pink if it is available. And what the statement made in the petition filed by the respondent under section 125, she has stated that the petitioner monthly salary is 30,000. Although the objection was made before the learned trial court, but the learned trial court, without relying the submission made by the petitioner and without relying the document that is submitted by the petitioner before the learned trial court, it is also reflected. Kindly peruse page 45, my lord. It is specifically mentioned that relevant portion, my lord, fourth para, the petitioner stated that opposite party is a habitual drunkard and inflicted continuous torture on her, for which she is compelled to live separately from the opposite party. It is stated that she does not have sufficient income as the opposite party has failed to give any maintenance allowance to her till death. She is facing great financial hardship to maintain herself and her minor son. It is further stated that opposite party is working in a private limited as a senior assistant, draws monthly salary of rupees 30,000. Well, that is the learned trial court below relied the false statement made by the respondent, whatever it is made in the petition filed under section 125. But the document, that is the salary slip, that was not relied upon, which is also filed on affidavit and which is available on record. So, on being aggrieved of that order passed by the learned trial court, the petitioner preferred this petition before this honorable court for setting aside of that order, because the petitioner already filed a petition under section 9 for restitution of conjugal right. He is still awaiting to continue his conjugal right. And what is interesting, my lord, the son of both the parties name, the son of the both parties name is Dipankar, but the respondent who has filed the petition before the learned trial court, she has mentioned that her son's name is Utkarsh. Utkarsh, they is not the son of the petitioner. So the petitioner approached before the learned trial court for a direction to submit the birth certificate of that Utkarsh day, that will definitely reflect who is the father of that son. So without hearing, without relying upon that document, the learned trial court passed that impugn order. So the petitioner, without having no option, was compelled to approach before this honorable.
Challenge the paternity.
My lord?
You also challenging the paternity.
No, I'm not challenging, but my name of my son is Dipankar De. And the respondent mentioned that her son's name is Utkarsh De, so, which is not true, my lord. So the petitioner approached before this honorable trial court for giving a direction to submit the birth certificate of that Utkarsh De, whereas the respondent till today failed to submit the birth certificate.
Where is the order? Order is there. Directing the respondent to submit the birth certificate. Where is
No, I prayed for a direction. I prayed for a direction before
by filing a petition.
Submission was made during trial, during hearing of that interim maintenance.
No, in that regard, have you filed any petition?
I have also mentioned in.
No. Have you filed any petition for direction to the respondent to file the?
That is mentioned in my objection also. That is mentioned in my objection also of that interim maintenance. Kindly peruse, my lord. And she also mentioned
My lord, kindly peruse page 42, my lord. Relevant portion, para 9. I filed, I prayed for a direction, my lord. Page 42. The respondent begs to submit that he is duty bound to take care of his wife and son, Dipankar, but he is not in a position to give maintenance to his wife who deserted him willfully and one child whose name is Utkarsh. The respondent further would like to make it clear before the Honorable Court that his son's name is not Utkarsh. As such, this Honorable Court may kindly be pleased to give a direction to the petitioner to submit the birth certificate of the child Utkarsh, showing that respondent is the father of this child Utkarsh. And in the prayer section also, my lord, it is mentioned that for giving a direction to the petitioner to produce the birth certificate of Utkarsh on affidavit before the Honorable Court, my lord, that was not considered, and even respondent till today failed to submit that birth certificate. My lord, on the very first day, Honorable High Court interfered the order and was pleased to reduce that amount to 5,000. And as per direction of the Honorable High Court, the petitioner is paying the amount regularly, and the petitioner is still today, my lord, is ready to bring her back and want to continue conjugal life.
This was the interim order. No?
Yes, ma'am.
It was an interim.
Yes. At least, my lord, for the interest of justice, my lord, some reaction may kindly be given.
Where is your pay slip?
Page 42, my lord.
Pay slip, pay slip. Pay slip.
Pay slip, yes, that is on record, my lord. Pink color flag mark. That is easier. Withdrawing monthly salary is 19,000 like that. And she has mentioned falsely that I am withdrawing 30,000. The learned trial court realized that false statement.
That it is a private company.
Yes, ma'am.
So who issued that your pay slip?
That is computer generated.
Then how will court believe this one?
Yes, my lord, heading there is.
Where at the time of filing your WS, you filed this one or where?
After at the time of evidence on assistant liability, at that time
Assistant
it was
liability.
yes.
And where is the assistant liabilities of the other side?
And she has mentioned limited income, whereas she is also has income source, my lord.
No, birth certificate of Dipankar Day is already furnished here.
Yes, that is furnished by me, but she has made a statement that her son's name is Utkarsh Day. She failed to furnish that birth certificate. Utkarsh Day is not the son of the petitioner.
Where she has mentioned that son's name is Utkarsh.
Yes.
Where, in which page?
In her page 23, my lord, paragraph 3.
School, while admitting the school, his name is Utkarsh, I think.
No, the permission was not taken from the petitioner because she willfully deserted the house of the petitioner and she is presently staying in her parents' house. So without taking any permission, without informing the petitioner, she took admission in that school.
She has to admit her child, no? How she will?
Yes, my lord. Although the petitioner tried his best to find out that birth certificate, but he could not collect. Until and unless, my lord, direction is given by this honorable court, my lord, the respondent will not submit that birth certificate.
Her access and liability is also here in the petition itself.
That is not available with me, but that is on record in PCL. My respectful submission before the Honorable Court is that the petitioner, as a legally married husband and as a loving father of the child, is duty bound to give maintenance to his only son. The name of the son is Dipankar, but she is seeking maintenance to one son, Utkarsh. There is the
You are Mr. K. Kalitan. You are Mr.
K. Kolita.
K. Or Mr. K. Kalitan.
Yeah, please, Lordship.
The learned.
I am paying for the respondent here, my lord.
Oh, now you have come.
My
Where from you have come?
my lord, during the course of hearing, I came, my lord.
You were here.
My lord.
Oh, I didn't see you.
Lord, in fact, your lordship just now gone through that assets and liability of the both the parties, my lord. But it reflects everything. Apart from that, my lord, may I draw your lordship's attention to the petition filed by the petition that respondent hearing before the 125 petition, my lord. Paragraph 6, my lord. Lordship, kindly look in paragraph 6, my lord, there.
There are 6 of the petition.
My lord, page 24, my lord. The petitioner, may I read, my lord? Paragraph 6, page
Your petition.
my lord, his petition,
No,
page 24, my lord.
125 applications filed by you.
My lord. Your lordship got it? Paragraph 6.
Yes.
That the petitioner expressed that soon after her discharge from IMC hospital, she, along with her newborn baby, returned to the matrimonial home, that is the rented premises of her husband. The petitioner noticed that the resident respondent's attitude and behavior was different towards his newborn baby. The respondent was more occupied on his own life and spent less time in his newborn baby and the wife. And the petitioner further expressed that the respondent was very much reluctant and carefree to pay attention towards his wife and petitioner's health during her post-pregnancy phase. The petitioner post-pregnancy phase demanded the medical attention for herself and her newborn baby. Not only that, during her sex phase, she was in urgent need of regular supply of nutritious food, supplement, and other medicine, but the respondent willfully neglected to fulfill sex requirement of the petitioner and her newborn baby. The petitioner repeatedly had to seek financial assistance from her husband and the respondent for procuring the nourishment necessary item for herself and herself, and only after such persuasion, he would give some measure amount of money to the petitioner. Such type of behavior and attitude would respond worried the petitioner very much, and finding
It's
no
okay.
way.
In cases I
that-
can understand.
Of
Some mental, physical torture, whatever, she had to left her matrimonial
Malad, in fact, Malad, she is in such a position now, Malad, hand to mouth. Her only aim in life to, Malad, how to uplift her minor child and good education, everything. The name which is alleged by the petitioner, Malad, definitely at the time of Malad, at the Hindu ritual, Malad, some name is better at the time of admission. Malad, name was that type of malat our malat Hindu ritual. That is why her son's name was initially in the birth certificate. Hurriedly, soon after the birth, some name was given. But at the time of admission, that is why definitely see Utkarsh would as per the Pandit Hindu Pandit's suggestion, she has done this. Malat. In fact, Malat, in the assessment reliability is reflect everything, Malat. Ours stand in the petition, the 124 petition is that the present petitioner's income is 30,000. He produces assessment liability, a salary slip that is a computer generated. Malat, without any signature, Malat, 19,000. Even though Malat, the amount which was given by the interim relief given by the line of time, there is a meager amount of 7,000 only, Malat.
That is
Malat, at that present stage, Malat, with a child, not to say about myself, Malat, the child, the upliftment, Malat, 7,000 is not enough even. So, the rest, I left to your losses to decide, Malat. So there is nothing to Malat interfere with the learned tribunals or that line of courts below order. The case is pending for that court, Malat. Malat,
he is raising other issue. But in his statement, assessment liability statement, he already the next one salary certificate. Obviously, it is a computer generated.
Malat.
To substantiate your plea that he is earning rupees 30,000, whether is there anything?
Malat,
Because it is
as
also
a
your
housewife, as a housewife during our conjugal life, that is the belief. That is as a housewife. That is I am not going to inquire anything in the papers, Malat. That is the belief as told to the wife by the husband. That is why I made such a statement that his earning is 30,000. She got married to the person with some belief, but in this subsequently after
no,
that part of the baby, it appears that he is totally neglected to his family, Malat.
Totally
It
false
is difficult to Malat for a lady to Malat for a bring up a minor child to a Malat good in the society. Present, Malat, it is a little difficult otherwise, Malat. So that is a statement. I am not in support of that. Ulysses pointed out no documentary evidence before me. As I was told by him, 30,000 he earns. That is why I made such a statement. But this is a computer generated. Well, that can also not be believed without any signatory authority.
This is file on affidavit, my lord. This is file on affidavit.
That is his affidavit, my lord.
Yes.
And in the assets and liability affidavit, Ulysses kindly look into it in the first paragraphs, how he Malat supported that affidavit. That is also required to be looked into, Malat.
How he?
Malat, how the other Malat, apart from the income, other queries are also there, Malat. How it appears that nil that way the affidavit has been filled up. So it is difficult to Malat believe his affidavit.
No. Just properly filed. This honorable court always relies upon any document, my lord. And whatever the allegation made in the petition, that will be verified after enlistment of evidence.
Accession liability affidavit as per Judges Neha's case. Those are required to be made up properly.
In case of proprietorship firm, business partnership, these are.
Yes, my lord, this was properly filed, and this honorable court always relies upon the document. So I am always duty bound to give maintenance to my child and my wife. I am ready, but I am ready to give maintenance to my son Dipankar. I am not ready to give maintenance to one Utkarsh there. My lord, at least
What is this?
that is
And
that
in
is the
fact-
main thing, my lord.
In fact, my lord,
That's why the
she is
petitioner
in
was.
fact the position.
That's what I'm
She
saying, the
even
action-
could not able to fight before the learned court below also, my lord. She don't have such money, my lord. Her income source is very limited. Without this amount, she cannot survive with her.
He willfully deserted, and
My
all
lord,
the
the way this he treated, it is not impossible, almost impossible to live together now, my lord.
totally false allegation made in the petition, just to make out the issue.
Even in my lord, reply to his restitution of that section 9 petition, I have not such money to engage advocate for go for a divorce case, my lord. I am such a position in a such a
He is
position.
not filing divorce, he is filing the restitution.
I
Again,
still
I could
trying
file
to
a
continue my
divorce
conjugal.
petition because it is not impossible to remain with him, my lord.
The family members of the
Even I
respondents.
cannot go for file because without money I cannot go for file and divorce petition. Even to defend the case, it will be difficult.
Whereas, my lord, the petitioner is ready to continue his conjugal life, and the learned counsel appearing on behalf of the respondent made submission about the divorce. Divorce is not the issue, my lord. He had the birth certificate, and I have honestly made submission that I am duty bound to give maintenance to my legally married wife.
See, don't make a such question that give to birth certificate. Birth
Yes, my lord.
certificate, obviously, he is Dipankar. As per the birth certificate, it is admitted by other side also, he is Dipankar. But at the time of admission in the school,
But Utkarsh Day is not the son.
Name is written as Utkarsh.
My
That
lord,
is it.
that was not informed, and that is not aware by the petitioner, my lord. That is
Don't
at least direction may
give
kindly be
such
given, my lord.
information. From whom she will seek for maintenance, because admitted position is as you have a male child.
Yes, my lord. But Utkarsh Day is not the son of the petitioner. That is my lord.
For other sons, she will seek maintenance. For son of some other
Dipankar,
person,
yes, the Dipankar, he is the.
no. For some other person, she will seek maintenance for other child.
My lord, at
She
least,
will not seek maintenance for her own child, but she will seek maintenance for other child.
my lord, for the interest of justice,
Now
my
you
lord.
just say me,
Yes, my
because
lord.
admittedly you have a son.
Yes, my lord. Yes.
Marriage is there, you have a son. That is okay.
But
admitted
Utkarsh Day is not known to the petitioner. That is the main thing, my lord. Utkarsh Day is,
that means you are saying that she is seeking maintenance, not for her own child, but for some other child.
my lord, I'm not.
That is your case.
No, my lord, I'm praying for direction to give, to furnish the birth certificate of.
How he will file birth certificate? Because birth certificate is only Dipankar Day.
Yes, my lord, that is available, and she suddenly sends without.
She can
without knowledge of the petitioner, my lord.
As to why or as to what under what circumstances name has been changed.
My lord, I leave it
That
to
means
this honorable court. Yes, my lord. But at least direction may kindly be given.
You are not going to pay for Utkarsh, you are going to pay for Dipankar. She is seeking maintenance for any other child, other man's child, not for her own child. Can it be? Can it be? Just think of it. Just think rationally.
That is,
rationally, you think.
But
his name may be changed.
In the initial stage of my submission, my lord, I am.
And then obviously I do agree with you that before changing his name or whatever, admission, at least minimum your permission should have been taken. Or
Yes, my lord.
Intimation should be given to you.
Yes, my lord.
That is okay. Don't bring this allegation that he is the son of others.
At least direction may kindly be given, my lord. At least for the satisfaction of the petitioner, because.
Heard Mr. K. Kalikati learned counsel for the petition, and also heard Mr. UK Samiti learned counsel appearing for the respondent number 1, and Mr. P. Botaku learned additional PP appearing for the state respondent. This is an application for in the section 482, section 397 CRPC against the implement order dated 01/08/2023 as by learned principal Judge Family Court number 2, Kamrup M, Guwahati in FC, record of criminal case number 327 of 2022, directing the petitioner to pay interim maintenance of rupees 7,000 per month. It is submitted by Mr. Kalita, the learned counsel for the petition, that they were happily married in the year 2015, and initially the case was also registered before the marriage officer Kamrup M, Guwahati on 29/09/2015, and thereafter the marriage was also solemnized socially. Male child is also born today out of their wedlock, and on 25/07/2016. But after the birth of the child, the petitioner, respondent willfully deserted the petitioner, and since January 2017, without any valid reason, she started living in her parental house along with their minor child. Thereafter, the petitioner also filed with the application for restitution of conjugal rights. Is it pending still?
Yes, madam.
In which
Can in principal just number 2, madam. 2.
number 2?
Yes.
Restitution of conjugal rights under section 9 of the restitution of the conjugal rights, and it's the same same is still pending before the learned principal judge Family Court number 2, Kamrup. After institution of the said restitution of case of the restitution of conjugal rights, the petitioner filed a case of maintenance seeking maintenance from the present petitioner. While filing the present application, the petitioner had submitted that it is stated that the respondent has stated that the petitioner had his monthly income of rupees 30,000 without any supporting. On the other hand, at the time of filing the assets and liabilities along with the written objection, the petitioner had filed his salary certificate, which is a computer generated copy, wherein it is written that he is earning salary of rupees 19,000 from the company where he works. The assets and liabilities were submitted on oath and with an affidavit, where he stated his monthly salary as rupees 19,000 per month. Apart from that, at the time of filing his written objection, he also raised the issue that the name of his child as per the birth certificate is Dipankar Day, but the petitioner had mentioned, but the respondent had mentioned in her petition the name of the child as Utkarsh Day, who is not the child of Utkarsh Day, who is not known to the present petition. In view of this, for which the petitioner also prayed for a direction to the respondent to furnish the birth certificate in respect of state Utkarsh Day, who is claimed to be the son of the present petitioner. But without considering all these aspects of the case, even not considering the monthly salary of the present petitioner, the learned principal judge had passed the order of interim maintenance only on the verbal submission made by the respondent, and respondent considering the monthly income of the present petitioner as rupees 30,000. Accordingly, it is submitted by Mr. Mr. Kolita that the interim order, which has already been passed by the learned principal judge directing him to pay rupees 7,000 per month, is liable to be set aside and washed, and the learned trial court below may be directed to heard both the parties on SSN liabilities, and also the question in and also in respect of the name of the child as brought by the respondent. However, he submitted that being his wife and child, he is always duty to pay maintenance to them, but he is not in a position to pay maintenance of rupees 7,000 per month out of his income of rupees 9. Next paragraph, Mr. Goswami, the learned counsel appeared for the respondent, submitted respondent number 1 submitted in this regard that the learned principal judge family court and rightly passed the order of interim maintenance, and there cannot be any reason for interference. He said. He further submitted that admittedly the name of the child was Dipankar Day at the time of issuing birth certificate, but as per some Hindu rituals and all, the child is admitted in the school with name Utkarsh Day. Further, he submitted that though she could not submitted any documentary evidence in regards to income of the present petitioner, but it was from her belief. She stated that he is earning rupees 30,000 per month, as told by the petitioner himself during their conjugal. He further submitted that the child has already admitted in the school, and she is not even she is not even positioned to maintain herself along with his child with a meager amount of rupees 7,000 per month, which has already been granted by the learned principal judge towards the interim. He further submitted that the respondent had already brought all the reasons in her petitions as to why she had to leave her matrimonial house along with her newborn child. Accordingly, he submitted that there may not be any interference in the order passed by the learned principal judge towards the interim. Next part, during the submission made by the counsel for also to take this actions while petition. It is a evident fact that the respondent is staying in her matrimonial house. Staying in her parental house, leaving her matrimonial house after the birth of the child. Both the parties have also filed their assessment liabilities along with their petition as well as with WS of the written objection. Written objection wherein it is stated that the monthly income of the present petitioner is 30,000 per month, 30,000, while submitting her SSN liabilities. On the other hand, it is the claim of the petitioner that he is earning only rupees 19,000 per month, and to that effect, he also produced a salary slip which is a computer generated. Hearing this submission made by an counsel for sides, it is also not, it also cannot be believed that the petition, the respondent will seek for maintenance for another child, leaving her own child, who is the Pankor Day as per her birth certificate. However, at present, the name of the child is stated to be one Authorised Day, and in that regard, the learned child court below may consider this aspect and may pass any appropriate order to that. Next, coming to the amount of maintenance granted to the present petitioner, granted to the respondent, it is seen that the considering the monthly income of petitioner as rupees 30,000, the interim maintenance was granted towards rupees 7,000 per month. But considering the all other aspects of the case, including the present, including the salary certificate issued by the company, salary certificate produced by the petitioner at the time of filing his SSN liabilities on affidavit. I find that a simple, a slight modification, maybe slight modification of order may be passed. In that regard, if order may be passed, in view of this, the petitioner is hereby directed, and then in view of this, the order dated about 1/8. 01/08/2023 is hereby slightly modified to the extent that the petitioner will pay rupees 5,000 per month till the disposal of the said maintenance applications, with a further direction to the learned principal judge, family court number, so to dispose of the matter within a short possible time, preferably within 6 months, preferably within 3 months from the date. With the above observation, the present petition stands.
Deeply obliged.
I am for inform number 2. My son died.
You are for the informant.
My son died. Because this is a 204A case. And due to
hold
the
on,
gross
I'm going
negligence-
to you have your scope. Let me start.
That's to, first of this.
No, but 304A was there.
Where was that prima facie case against the petitioner? Due to the gross negligence of them, my son died. We repeatedly approached before the due to their negligence, but they did not take any action. And for that, it is in the charge sheet, my notice is clearly written that they are the solely responsible person. So how can this matter may be questioned?
That is all right. Let me submit, my lord, then his turn will come. My lord, I have presented this petition for consideration.
I have checked that here, my lord. Here, my lord. Then I have studying the there nothing with it.
161 is not there. So then too, it may not be hard. CD is not there.
Statement of truth. The DM report is there.
Let me start, my lord. Perhaps all those things will not be necessary, my lord. Because there is a, my lord, technical issue in the entire matter. That your lordship, my lord, that will be the first hurdle for them, my lord, and that perhaps they will not be able to overcome.
Okay, then let him
Yes,
start.
yes, my lord.
Okay,
So, my lord, it is a fact that, my lord, somebody had died, and it is an unfortunate event that, my lord, somebody has lost his life, my lord. The question now is whether, my lord, just because somebody has expired, my lord, and it was an accident, my lord, and an unfortunate event, whether, my lord, two serving officers of the Assam State Electricity Board could be roped in by saying that, my lord, they were negligent, and because of their negligence, my lord, this incident has occurred, my lord. Now, for the sake of argument, my lord, let us, my lord, take it without admitting anything that there was some.
Oh, अच्छा. Anyway, okay, yes.
Yes, ma'am. So, my lord, now if your lordship kindly turns to page number 18, my lord, that is the charge sheet which I have given, my lord. It starts from page number 17, lordship will come to page number 18, my lord. The last column, my lord. It starts with the word position, and then, my lord, the sentence starts. There is a lordship here, page number 18. The accused persons, Protus Protim Debnath and Prankrishna Mohanto, both were SDE and junior manager, APDCL Badorpur. So that part is admitted, my lord, that these were the subdivisional engineer and the, my lord, junior manager of the ASCB, my lord, stationed at Badorpur. Now, my lord, for the purpose of serving officers, my lord, when allegations are made against them, my lord, they are protected by the provisions of section 197 of the CRPC, my lord. And under the provisions of section 197 of the CRPC, my lord, the protection which is extended to serving officers is that, my lord, that before proceeding against them, my lord, or before prosecuting, my lord, serving officers, my lord, who are public servants, there should be a sanction, my lord, given by the appropriate authority so that they can be prosecuted against, my lord. And your lordship will see, my lord, now who are public servants, that has been, my lord, demonstrated under section 21 of the, my lord, Indian Penal Code, my lord. Section 21 of the Indian Penal Code, my lord. Public servant.
Yes.
Yes. If your lordship kindly takes up section 21 of the IPC, my lord. Public servant. The word public servant denote a person falling under any of the descriptions hereinafter following, namely, then, my lord, lordships may kindly skip over from and come to the explanation 12th. Every person in the service or pay of the government or remunerated by fee or commission for the performance of any public duty by the government. B, in the service or pay of a local authority, a corporation established by or under a central, provincial or state act, or a government company as defined in section 617 of the Companies Act. Now, my lord, it is aware, my lord, and everybody knows, my lord, that the Assam State, my lord, Electricity Board, my lord, in whatever different names they are known today, as the APDCL or AEGCL or whatever, my lord, these are, my lord, corporations which are wholly owned by the government of Assam, my lord. And if they are owned by the government of Assam, my lord, that these officers, my lord, who are prosecuted and who seeks the protection from this honorable court, my lord, They are public servants within the meaning ascribed to them under the Indian Penal Code, my lord, and they are protected, my lord. And to my information, my lord, that sanction, my lord, till today, even after filing of the charge sheet and the matter having been taken up for trial and cognizance having been taken against them, my lord. The learned trial court below, my lord, did not pay its attention to this aspect of the matter as to whether in the fact of there being no sanction against them, my lord, whether, my lord, these cognizance could have been taken at any point or not. Now your lordships will kindly see, my lord, come to the FIR, my lord.
FIR is the page.
Page 13, my lord, 1-3.
Yes.
I like to lodge a report with you that on 15/4/2019 at 11:30 a.m. while my son, namely Ansarul Haq Mojumdar, was proceeding on foot from my house at village Alakulipur towards his farm at Devendranagar near BBCL through the PW road, that is Badarpur Ghat, Adahar Kuna road. At that time, when he reached nearby his farm, one of the overhead high voltage line electric wires, which was already hanging in a dangerously low level, suddenly came down further and touched the head of my said son Ansarul Haq Mojumdar, as a result of which my said son died on the spot, and after the said accident he was rushed to the railway hospital Badarpur, where doctor declared him as dead. Autopsy over his dead body was conducted at Civil Hospital Karimganj on the same day, that is on 15/4/2019. It is further to be mentioned here that there was a long pending panic in the local people about the said dangerously hanging electric wire, and one of them made written complaint to the authority of the APDCL Badarpur subdivision in that regard, but the authority concerned did not pay any heed to his complaint. Lastly, I like to submit that as I was busy with a funeral ceremony of my late son, so and so, I could not file the FIR earlier. It is therefore requested that the matter be investigated properly and necessary steps be taken. Now there are two aspects of this matter, my lord. One aspect of the matter is when you allege, my lord, an act of negligence and attribute it to a person, my lord, whether, my lord, that allegation is in his personal capacity or whether it is in the capacity of a person who is serving a particular government corporation. That is one aspect of the matter. And the second aspect of the matter is now, my lord, I don't know whether those, my lord, allegations are there or not, my lord, because from the list of documents which is annexed along with the, my lord, this charge sheet, it does not reflect that there is any such letter, my lord, which has been brought on record, my lord.
Letter means from where?
They have stated that there was a long-standing demand and all, my lord, whether the demand was there or not, or whether whoever had, or whatever manner the demand was stated, this was not documented, my lord. My lord, it could be like this, that, my lord, your lordship's, my lord, assistant is here, my lord, and I speak to him, my lord, about some books and all, and I did not give anything in writing. And tomorrow, my lord, somebody comes and says that because I have stated to him and he did not produce the books, no, that is undocumented thing, my lord, that can never be relied upon, my lord. So if the allegation has been made at any point of time that there were, my lord, complaints made in regards to those hanging wires or whatever, my lord, now it ought to have been documented, my lord. In my respectful submission, there is nothing on record to suggest that there was any such record, my lord, to that effect. The second aspect of the matter is when your lordship again turns to the, my lord, charge sheet, my lord. They were the sole responsible to look after and inspect the above 11 kV line, and when which the said persons did not do it. If the said accused persons earlier inspected the line and repaired it, then this incident could have not been occurred. Now, having said that in the charge sheet, my lord, whether if you allege, my lord, negligence, my lord, when in the FIR itself it is stated that the lines were hanging low, my lord. If the lines were hanging low, what purpose did you have to go below the lines, my lord? Because it is stated in the FIR itself that suddenly it came down. And, my lord, now in this record, my lord, actually what happens under the electricity law, my lord, if there are cases of this nature, then there is a competent authority before whom you have to, my lord, make a complaint, my lord. And the competent authority on making the complaint will take the matter to the, my lord, electrical accident, my lord. There is an inspector of electrical accidents, my lord, who inspect the entire thing. And he has the powers of a civil court to call someone and request, my lord, record the evidence of the parties, my lord. and thereafter come to a conclusion. Directly, my lord, filing an FIR before the police, my lord, I'll place those laws, my lord. Even in my respectful submission, my lord, the police does not have any authority to investigate matters in this respect, my lord. Because this is not a case that where I had some animosity with that man and then, my lord, I had taken two live wires and then put it in his head, man. Hey, electricity act kon dibo niki? I say. Lordship kindly takes up section 161 of the Electricity Act, 2003.
Yes.
Notice of accidents and inquiries. If any accident occurs in connection with the generation, transmission, distribution, supply, or use of electricity, or in connection with any part of the electric lines or electrical plant of any person, and the accident results or is likely to have resulted in loss of human or animal life, or in any injury to a human being or an animal, such person shall give notice of the occurrence and of any such loss or injury actually caused by the accident in such form and within such time as may be prescribed to the electrical inspector or such other person as aforesaid, and to such other authorities as the appropriate government may by general or special order direct. So, my lord, the first action that ought to have been taken was, my lord, to intimate, my lord, to the appropriate authority that such an event had taken place, my lord. Then, my lord, what, kindly see, my lord, in 161(2), the appropriate government may, if it thinks fit, require any electrical inspector or any other person appointed by it on his behalf to inquire and report as to the cause of any accident affecting the safety of the public, which may have been occasioned by or in connection with the generation, transmission, distribution, supply, or use of electricity. Then, my lord, lordship comes to subclause 3, my lord. Every electrical inspector or other person holding an inquiry under subsection 2 shall have all the powers of a civil court under the Code of Civil Procedure so and so, for the purpose of enforcing the attendance of witnesses and compelling the production of documents and material objects. And every person required by the electrical inspector be legally bound to do so within the meaning of section 176 of the Indian Penal Code, my lord. So that is the power and authority, my lord, of this organization, my lord, to whom, my lord, the report or the complaint was to have been made. Having not been made, what happened was directly, my lord, they went to the, my lord, police, my lord. Now, if your lordships, my lord, kindly turns to page number 1. Is your lordship
here another for 5 minutes?
I don't know. Okay, my
Just continue for 5 minutes and then I'll.
my Then if your lordship kindly turns to, my lord, section 151, my lord,
151
of the Electricity Code, my lord, the Electricity Act.
Yes.
Cognizance of offences. No court shall take cognizance of an offence punishable under this act except on a complaint in writing made by the appropriate government or appropriate commission or any of their officers authorized by them, or a chief electrical inspector or an electrical inspector or licensee or the generating company as the case may be for this purpose, provided that the court may also take cognizance of an offence punishable under this act upon a report of a police officer filed under section 173 of the Code of Criminal Procedure so and so, provide further that a special court constituted under section 153 shall be competent to take cognizance of an offence without the accused being committed to it for trial. Now, my lord, lordship comes to page section
And
151A.
to go, it will be remain as a part heard
My
for
lord.
tomorrow at 2 p.m.
My-
Part heard to go. We are listing it and through a supplementary.
Yes,
call
yes,
list.
yes.
Two p.m. On by state. We are listing at 2 p.m.
Yes.
Rest of the matters, I don't know if time permits.